Decide the registration application. Yes.
Writ petition not I filed the petition challenging the action of the respondent. I filed the writ petition not challenging the
Fresh
writ petition.
petition.
No. That was not
Why do you want its listing?
clear it was listed.
Final hearing.
Not admission, admission only. For admission only, correct?
Admission. 11th October.
By not dated 4 weeks. But I was directed to I filed application. So please fix a date, otherwise it's coming up for repeat.
All right. 1710.
check for medical.
Yeah, urgent. Today. Yes. 1 minute. Yes.
Lordships, with great respect to this honorable court, Millard, matter pertains to the minimum wages which affected 47 lakhs workers who are discharging in 5 scheduled employments, Millard. IA to be considered by this honorable court. They were not appeared before this honorable court. Yesterday I had conducted the meeting and sending the recommendation to decrease the wages which have to be increased 15 years back, Millard. I have already informed to other side, Millard. Kindly have it the lunch motion or Monday, your lordships, with great respect to this honorable
Monday.
Obliged.
9:10.
Okay. Deeply obliged.
Yes.
Your Lordship, and it's a commercial court. It's a commercial court appeal, my lord. Asking for the modification of the interim order. This honorable court has directed to deposit the 50% of the amount. We are asking for the withdrawal, for the permission to withdraw.
12:10. Or 10:10. 10:10.
Your Lordship,
10th October.
My lord. Yesterday my lord met
Give. Yes.
with your Lordship, point.
Madam, send this to. Yes.
While my job removal case was pending in the court, the respondent illegally broken my quarter lock and removed all things. So I filed a direction petition for handing over my things.
No IA. You tell him. You need. You are being told there is an interim order directing you not to file any interlocutory application so long as that order stands. Every time you stand up, we can't help it, mister. You will have to challenge that order before Supreme Court or whatever. The order prevents you from filing IA. Every time you file IA, what can be done?
But this is a non-service petition. That is a writ appeal service.
They will appoint to some person to assist you because it is not our job to explain to you what are the things. So we will appoint somebody. Yes, who will assist?
It is
Mister. Yes, come forward. You make that person understand, go through his record, what difficulty he has reasoned it out, and understand this case. Every time we have been telling him there is an interim order, rightly or wrongly, a bench of this court has passed an interim order restraining him from filing any interlocutory application. He files interlocutory application every time. It can't be done, right? He is committing contempt. We don't know whether until so long as that order stands. What can we do? He has to make an application for recall of that order, do something. You please explain it to him. This is the problem. And our party in person committee permits all such persons to appear. Mister, you better find out how the committee, how he has been able to convince the committee that I am competent to argue my case. Oh, there's nothing. Understand, right? He will help you. So please understand from him. You tell him what is the course of action, what should he do, guide him. Because he is not a person, he is obsessed with that my quarter has been broken down. So what can be done? His accommodation has been broken down, already broken down. What can we do? Damages, etc., whatever. Tell him what should he do. But you please talk to him. He will explain it to you. What should you do? It's not that for every grievance there is a remedy, right? But you must pursue the remedy in accordance with law. Got it? It's not that you may have been wronged and you have the right to approach the court, but do it in a proper manner. We can't permit because just you are appearing. So he will explain it to you. Please understand from, and he will tell you what to be done. And you appear, Mr. Assistant, whenever he comes. You understand from him what is the case.
Yes.
Please speak to him. He will assist you. Yes.
My lordship, this is the 7567 petition of 2023, my lordship. The petitioner has not been received his pension since 2012, my lordship. And the matter has not been listed for several months, my lordship. Kindly.
Several months. Why do you want listing? Final hearing. Make an application for other. Every day, madam, we tell you like this. Yes.
Your lordship, kind permission.
If you want final hearing, please move an application for early hearing.
With the lordship.
Right?
It's a intra-court writ appeal filed by government.
Fresh matter.
Fresh matter.
When? Yesterday filed.
No. It listed twice, thrice, they got adjourned at the instance of the government. Urgency is the malad. Writ petition has been filed.
At the appellant.
No, I am the respondent. Writ petitions. Writ petition has been.
So there is no interim order.
No.
That
No, this coming for admission, price.
so it is their appeal. There is no interim order. Do whatever you can.
Urgency, my lord. The inquiry has been initiated to cancel my ST community certificate. That has been challenged the writ petition. Writ petition are allowed. Now, in view of the pending of this writ appeal, we are writ petitions are denied of caste certificate, community certificate. Now they are applied for higher studies and employment.
No. So there is no stay, right? No stay directing not to issue caste certificate to you.
No, in spite of it, pending.
If there is an order, file contempt, they will automatically, get it listed. No stay operating against you. No stay, how can you force a person who has filed an appeal to argue on admission? You are virtually forcing them to argue. No, you must argue on admission. Why? There is no, if there was a would have been a stay, we would have understood. Yes.
My lords, with your lordship's leave, this but a fresh matter, my lords, medical admissions, NRI quota, the petitioners have to be, my lord. Today, my lord, lunch motion. Much obliged.
Yes. Yes, Mr. You wanted, no, nobody.
Yes, Your Honor, Narendra Agrawal, party person. Am I audible, Your Honor?
My lord.
So which case?
Audible?
Which case?
My lord.
Your Honor, I have filed a case CC number 1446 of
You will have to give a memo, Mister. You will have to give a memo if you want its listing, CC.
Your Honor, I was told that because matter needs to be listed for Your Honor, Justice Vijay Sen raised the bench.
We don't know who told you. Who told you?
I requested
Definitely, I did not tell you. I am seeing you for the first time.
Yes,
I
Your
did
Honor.
not come to your residence and tell you that I will hear your case.
No, Your Honor. I'm appearing for the first time.
Somebody told me means who told you?
Registrar, Your Honor, was
You have to approach Mr. Registrar Judicial for this. This is a separate combination. We don't know. But you perhaps, it's better that you know what you say. This can't be done. And Mr. You, who are the persons, party in person, all they are permitting all such persons who don't understand anything.
Your Honor, my request is listing.
Listing you have to Registrar Judicial. Mr. It's a different combination. In this combination, the mention cannot be made. Please understand. Yes.
Thank you very much.
Registrar Judicial, you talk to, please talk to Registrar Judicial. You
Thank you.
yes.
Thank you.
He will take action for constitution. Yes.
My lord, double bill 26 2023, it's not coming into the list, my lord. Actually, it is related to health issue of environment, my lord.
Not coming.
Kindly,
Who is preventing? Not coming means who is preventing its listing?
My lord, actually, this honorable court has posted for after 2 weeks, my lord. But unfortunately, the section is not giving the date, my lord, and they are asking.
No,
to
no,
mention
sir,
before the
it can't be. It can't be that the no date can be is given. There has to be a date. Mister, we are not sitting here to explain how system works and all that. Where is the memo? Where is the memo for listing? Who will, like this video conferencing doesn't mean you come and give a memo. It will be listed.
Oblige, Miller.
Yes.
Thank you, Miller. Thank you. Thank you.
One item, one. Which one?
Yes.
The delay of 146 days is 5 lakhs.
Hmm. Yes.
Delay of 146 days in 5 lakhs.
Condone, argue on merits. What is there?
Lord, the matter comes under KP scheduled area land transfer regulation,
Hmm.
and the land single judge dismisses the case.
That order passed in the proceeding initiated by your predecessor has attained finality and that binds you. That is the finding recorded by learned single judge. Correctly so.
Yes, my submission is that, Lord,
Ah.
the land single judge at page number 31, page number 31 said that we filed three revision petition, three appeals and filed only one revision that is not maintainable under law at page number 31.
No, the order earlier passed is final and binding. That is another finding. How do you get over this?
My submission is that, Lord, in fact, what happened in this case, Lord, they are the owners of the land, and by virtue of partition, they became the owners of the land. And my submission is that, Lord, kindly see at page number 52. The primary authority sumo initiated the proceedings in the year 1987, and in the year 1987, it passed the order at page number 53.
Right?
At page number 53.
Yes.
At page number 53, para number 2 and 3, the respondent failed to file counter documentary evidence, sale deed and Pahani copies in support of his claim, even though ample opportunity was given to him. In view of the above possession of respondent over the land after enforcement of amended regulation is illegal, unauthorized and contravention. No opportunity was given. 1987 initiated. In 1987 itself is disposed, and necessary parties were not included in this proceeding. And then, Milord, I have filed the appeal before the appellate authority, statutory appeal. At appellate authority at page number 60, Milord, 61. 61 said that, Milord, para 3. An examination of record shows that ample opportunity was given to the appellant. She has not filed any documentary and oral evidence to prove contention that the court land was come to her share in family partition. This primary authority did not give any opportunity. We have not filed any counter and not filed any document. The appellate authority acknowledging that ample opportunity are given. And then, Milord, there is a statutory remedy of filing the revision before the appellate revisional authority under AP scheduled area land transfer regulation. But what happened, Milord? The clients mistakenly filed 3 writ petition. That is at page number 68, Milord. Questioning the appellate authority order, page number 61. At page number 70. Page number 70. Last line. Last line 70, last line. The land single judge observed that it is well settled that when an order of the statutory authority challenge the perceived aggraved as to show grave error apparent on the face of the record. Opportunity was not given. Principles of natural justice. What grave error is needed? And my submission is that, in the meanwhile, what happened? One of the key person died. These orders were passed against the dead person. The writ petition orders were passed against the dead person. The advocate who appeared before him also met with an motor vehicle accident, and he did not appear before the single judge, land single judge. And
What happens to the, again we are asking you, what happens to order dated 27/2/2004 in a writ petition which has attained finality? That will bind you. That's what learned single judge has held, and rightly so.
27 to 26, not 28, that is 29/9/2018 revisional order.
Yes.
Revisional order, page number 48.
So what is your submission?
My submission is that, my lord,
No opportunity of hearing has been given.
authority not given any opportunity. Appellate authority has not given an opportunity. Revisional authority has not given opportunity. Mechanically dismissed the claim petition. When it is a partition, the AP scheduled area land transfer regulation does not fit the provisions of AP scheduled area land transfer regulation.
He also looks, but he has to argue. Yes.
The AP scheduled area land transfer regulation comes into play if the land is purchased after 1970. The schedule came into force from 1970, February 1970. The transactions, alienations, sale transactions after 1970 is filed, and the government has authority to resume that land. But it is a partition, family partition. The land is, most of the land is family partition. Only my submission is that we not kindly remand the matter and direct the special deputy collector to conduct a fair inquiry. And meanwhile, what happened, Milord, page number, during pendency of the writ petition, a Gram Sabha was conducted. The land was mutated. Kindly check page number 76. Page number 76. We approached the revenue authority. 76 and 78. We approached the revenue authority. We said that because of partition, the land was mutated, divided among the family members. 76 and 78. The revenue authorities mutated the land, and pattada passbooks were also issued in favor of the family member. We are under impression that the matter was settled before in the year 1991. Therefore, we did not appear before the land single judge in the writ petition. Thereafter, we got a statutory right to prefer a review. We filed a review. The only submission is that nowhere fair opportunity was given. It is nothing but a principle of natural justice. An opportunity may be given, remanded back to the primary authority for conducting a fresh inquiry. Giving an opportunity. That is only submission.
Third on IA1 of 2020.
Then before your lordship is respond number 7 before the learned single judge.
Huh.
No notice served.
What has been done?
No notice served, no representation. Impugned order begins from page 13.
You will also be heard by the authority. What is there?
Issue is the seventh paragraph, lordship. Status quo has been directed to be maintained. Still they decide.
So you are not in possession, right?
We are in possession. It's not just about possession.
How are you aggrieved?
We also wanted to alienate. The issue is
Who wants to? You want to eliminate?
that regardless, we should have been heard because the point remains the claim of the writ petitioner is not as regards my land. No rival title claim over the land. They claim I have already sold my land and I'm in possession of excess land.
One minute. Why did you include respond number 7? And how she has not been heard and this order of status quo?
Lord, with the leave of this honorable court, my lord, I am permitted to assist this court. My lord. I am the respond number 6, my lord, none other than the brother of the appellant, Lord.
Whatever, how do you justify an order without giving an appointment? Why did you include then respondent number 7 in the petitions?
I am not the, my lord,
Then-
counsel for
Who
petitioner.
is the petitioner?
Lord, he is the one.
My lord.
So you are right preparing the case now, right? So but turning pages means you are not ready preparing right away. So so you knew that there is no need to read the or any file because this order cannot be sustained. It has been passed without hearing the appellant.
No, my lord, that is not the case, my lord.
Not the case. When respond number 7 was served.
My lord, the writ appellant over here and the respond number 7 in the court below are the true brothers. My lord.
Then there is no court below, Mr. We take a strong action to this, Mr.
My apologies for that, my lord. Before the learned,
Oh, what is this? I mean, you are telling before the High Court itself, describing another honorable single judge of this court, court below.
my apologies, my lord. My apologies, my lord.
Go somewhere else below.
My apologies.
Don't come to this building.
My apologies. Honorable learned, sir.
All of us are equals. Don't, Mr. We don't appreciate this. Below.
Apologies, my lord. Sincere apologies for that.
Have we been heard? Simple thing, Mr.
Respond number 7 was heard. He filed a counter over there, my lord.
All right.
He's referring to respond number 6.
Respond number 6. Respondent 6 has filed a
You
counter.
tell him he was sleepy. You tell him that what is your case.
My lord, with respect to the
So we will record your submission that notice was issued to respond number 7 and when it was filed an affidavit.
my lord, with
Respond when notice of the writ petition was issued to respond number 7 and when it has been served, file an affidavit. And if it is found to be incorrect, your client will go to jail. All of them.
Honorable court, kindly bear with me for a moment, my lord. With respect to whatever the order which has been passed, my lord. It clearly says that notice has to be issued to the concerned persons who are over there.
If he makes an application within 2 weeks, suppose he doesn't make an application, the status quo will be continued forever. It can, in case of the applicant petition is not making an application. There is a condition. Can't be like. He doesn't understand, right? You need legal assistance? Arey, Mr. Anyone? Come. See, Mr. The respondent number 7. We will give you a copy of our this to understand. Make him understand. He is unable to comprehend. So what has happened is the appellant is respondent number 7 in the writ petition, right? So grievance is that no notice was issued to respond number 7 and order has been passed directing status quo, right? Status quo. So he is not able to understand this order cannot be sustained because this status quo will remain in operation.
Yes.
Like till a decision is taken and he has not even filed an application. So supposing if he doesn't file an application, there is no question of decision. So status quo will continue till the decision is taken, right? So this order, this type of order cannot be justified because respondent number 7 has not been heard. This point he is unable to understand. You ask him whether notice was issued to respondent number 7 in the writ petition before passing the order dated 20th day of June 2023. Please explain.
Yes.
Go there, you can't stand there and you will have to go to him. He needs your help.
If Lordship so pleases to permit me, my lord, I would like to, my lord,
All
assist this honorable
Fine.
my lord. I was
Yes.
the one who addressed.
You don't understand, right? What can be done? Heard on the question of admission.
My lord, respond number 6.
Heard on the question of admission. Don't understand, right? We wanted to dispose it off. These people don't understand. You suffer it out.
My lord, yeah.
What can be done?
Inspector.
Heard on the question of admission, learned counsel for the appellant subjects that even though respondent number 7 was arrayed, as even though
Make a request, my lord.
Also, my lord, I have been made appearance. Respond number 6.
condone delay, you write heard on IA 1 of 23.
May I make a request?
Issue notice and this thing, notice is accepted, delay condoned. Then heard on the question, dispense with allowed, then appeal is admitted. Without affording an opportunity of hearing to a party cannot be sustained. Supposing if you would have been respondent number 7, what is the difficulty? You should frankly say. You should have told the learned signal, yes, sir, there is a private respondent. Please issue notice to him because he will challenge that order on the ground he has not been heard.
This was ordered, my lord. I've even sent the notice also, my lord. But my instructions in the morning is that, my lord, it was returned back, my lord. So respond number 6 who filed the counter, my lord, saying that true brother, the court was
Delete, yes, madam. Delete that. Don't do it again, mister. This time we are correcting but this is not meant for wastage of time at the court. Our every moment is precious. Do you understand?
obliged.
Don't do it again. Yes. Heard. This intra-court appeal with consent, delay condoned, etc. This Yes. Password. Next.
Your Lordship, I'm representing the petitioner counsel, Mr. P.V. Krishna, Your Lordship. May I have this matter next week, Your Lordship?
Why? What happened?
The counsel is held up with some other cases. He cannot come, Your Lordship.
No, but you are there. Hmm? You are not held up anywhere. This is no ground to adjourn. Held up means what? Don't, madam, be, first of all, you all, how many years of practice?
Just 10 months, Your Lordship.
10.7?
10 months, Your Lordship.
10 months, good enough. 10 months you should know how to make a request to the court.
Yes, Lordship.
All of you seriously need an orientation program.
Next week, Your Lordship.
10 months you don't know what to tell the court. Do you know what you are uttering is not a sufficient ground for adjournment?
Yes, Your Lordship.
Huh?
Yes, Your Lordship.
Held up somewhere else? Where somewhere else? What, madam? This
Sorry, Your Lordship.
learned counsel for the appellant prays for adjournment. Petitioner prays for
Next week, Your
adjournment.
Lordship.
Right? You have a right to make a prayer for adjournment and that too properly, madam. You should have said that he is not available on account of personal difficulty. Don't say held up. Who has held him up? And you are saying that he held up in another court. That means the court has held up. Supposing if we ask you to stand in that corner for the whole day, then you will say that I have been held up by the court. Whether he has been.
Apology, Your Lordship.
Wait, Your Lordship.
Yes.
Lordship, this petition is filed by the petitioner, my Lordship.
Huh.
Not considering the presentation of petitioner, my Lordship, for counseling and admission into the PG medical courses under management quota, my Lordship.
Page number 66, my lord.
68.
66.
There is another covered matter, my Lordship. Pin number.
No. You don't want it's like to argue. We told you that every moment of this court is important. You want a similar order than 68, then you should have said first sentence. If you want to argue, we will decide. Go ahead. Yes.
Similar to my apologies, my Lordship.
Then, so why you are saying that there is another matter? Whenever that matter is called, we will see. We are taking up this case. 68 valid, certified copy today.
CC today, my Lordship.
May I please, I'm representing Mr. Raghavendra Rao Millard, the PG Medical Counseling, regard to,
Yes.
just to participate the counseling in the.
Petitioner filed a order copy of Amaravati. Page number 31, my lord. This is order copy with regard to AP, my lord, AP High Court.
No, that is, you consider his representation. Why did you not apply under competent authority quota?
Millard, due to the.
No, why you did not apply under management quota? It's your fault.
I stated in.
Can they be blamed?
No, Millard, I stated in my affidavit also, regard to.
Why you did not apply? Then how can you be permitted? We can't do anything at any counseling left, Mr. Now.
Counseling, my lord, for BDS admission.
Para 7, I have stated.
For BDS course, my lord, MBBS,
She is seeking admission to BD. He is seeking admission to BDA course.
PG, my lord.
This is PG course.
PG.
Sorry, my lord.
Counseling is held or it is.
Second phase counseling is completed, my lord.
So any other round?
So there is one mop-up round counseling.
What up round? Yes. So why? Who can be blamed? They can't be. Nobody prevented you from. No. Nobody prevented you from applying under the management quota. You have not done.
5 of my affidavit, I have explained categorically what happened.
What happened?
Millard, and also there is a.
No. So what happened means what happened?
On my side, Millard,
We don't know what happened. You are saying what happened.
unaware of.
What? See this how they argue the case. Really, I am amazed.
Para 5 of my affidavit, kindly consider.
We don't know, Mister, what you are up to. I really don't.
And also,
We will say that when asked, he said what happened. So we also don't know what happened.
no, I have stated in my affidavit, my lord, this is para 5.
So we are supposed to read it.
Lord, I-
We will say that instead of telling, he is saying para 5. Without, you are being engaged to argue the petitioner's case or to create trouble for the court. Tell us. Huh?
My lord, I am saying that on 23/9/2000 after the competent authority quota, convener quota, so the fact remains that I am unaware that the separate application has to be filed.
So unaware, we are also unaware that if we commit murder, we will be imprisoned for life. I am also unaware. So that ignorance is the
And
most.
also there is
Ignorance is bliss. Don't know. We also don't know.
page 23, my lord, there is an option also there.
We don't know.
Page 23, my lord.
See, there is no legal right that a person who
There
has
is an option to change also, my lord.
option to change.
Change of my second paragraph, last 2 lines, my lord. The candidates who are already registered need not register again. However, they will be allowed to edit their choice.
So you do it. It's not your case that. This is para 23, page 23 says a fresh schedule of round 3 onwards.
So with regard to all India quota,
Ah.
medical costing committee.
We don't know what legal right do you have to seek admission under management.
I have make a mail submission to them also, request to the page 24.
They will consider, Mister. We can't do anything about this. There is no legally enforceable right in you. Why did you not apply? I don't know. So nobody knows. If you are a doctor and a postgraduate student and still you say don't know, then only you should get yourself treated from the petitioner. When you fall sick, we will so you should seek this treatment from the petitioner who says MBBS doctor, young person 16, 17 years we could have understood. He is a doctor seeking admission in PG course and saying I don't know about rules of admission. That's why you are not reading it. Because you know that there is no expression.
On the ground.
Nothing, no, there is a misconceived petition. We are not prepared to believe that you did not know. Nothing, we'll dismiss.
My lord, I'm sorry, my lord, there is a representation also there, my lord, because
Okay, what is it? How can you say you are a doctor, MBBS doctor, right? MBBS degree you have. You are seeking admission and you say that I don't know the rules. Who will know? Patient will know the rules. Who will be treated? That you are entitled to admission under management category. He will tell you. Your patient will tell you if you don't know. See, what is absolutely frivolous. No right.
sorry, my lord, because of
No, we are not interested. Yes, there's no legally enforceable right. The petitioner.
my lord, at least
We are
consider
discussing.
my
To decide the benefit to the petition.
because of that.
You withdraw the petition with the liberty to this.
Sorry to my lord. Apologies to on behalf of
Consider.
petitioner, my lord.
See this, petitioner who is a doctor should see his performance. And you get treated by the petitioner, mister. Huh? Right? We will direct, provided you undertake to seek treatment from the petitioner every time you fall sick. Correct? Huh? We will record your undertaking also that every time you fall sick, you will only consult the petitioner.
I'm regularly using both
Huh?
of them.
You are going regularly, no?
Homeopathy.
No. Doctor, this is. Because petitioner is a doctor who doesn't know the rules of admission. He is appearing. He doesn't know the rules of admission. This is your defense. I was unaware.
Because of the petitioner, I am apologizing before the sample.
No. Not. Why should you apologize? You should undertake that I will take treatment from the petitioner. Right? Shall we record? Huh? You will go to the petitioner in case you fall sick. You don't have confidence in his capabilities. The petitioner is a don't disturb. That's all it.
Like, please, my lord.
Yes.
But the petitioner, my lord, is seeking an admission into the BDS court, my lord.
Huh?
But because of his health problems, my lord, he could not make an application for the management quota. But I'm only requesting this honorable court, my lord, to permit the petitioner to make a representation and let them consider my representation.
All right.
Your lords.
Permitted to file a representation during the course of the days. Same shall be decided. Following relief. When the Ah, yes,
Item number 7 and 8 are similar to each other, my lord. This writ petition has been filed challenging the action of the respondent number 2 and not issuing the provisional.
yes, Mr.
My lord, I am representing Deputy Solicitor General.
Huh?
I am representing Deputy Solicitor General, respondent first, second, and third.
Yes, madam.
The
You'll
facts
have
of-
to issue notice, right?
To the respondent number 4.
Four, because the according to you, the respond number 4 is the culprit.
Yes, my lord. Your lordship may have
Honest
been.
counsel for the petitioner submits that the petitioner was allotted as
Yeah, retired from Indian Air Force and now I am in practice.
Probably wrong profession. Or you learn fast. This is not like flying planes.
I will do.
This is something different, right? The argument doesn't mean that you tell the name of person twice to the court. Our hearing faculties and this thing are proper. If you tell, we are doing something constructive, not the unproductive thing like for whom you are repairing. What is the initial of Mr. Praveen Kumar? That's irrelevant.
My
1, 2, and we didn't ask your name. It's not an introduction session going on. This is a court, right? 1, 2, 3. Mr. So and so appears. Issue notice to personal notice.
Your Lordship, I have it on Monday because my grievances at the stray rounds
yes.
begin on Monday.
All right, list on Monday.
And your Lordships may even reserve the seats of the
9, 10.
petitions.
No, in the meanwhile, the seat allotted to the petitioner shall not be allotted to anyone else. Same order. The item 8 also same order. Certified copy today.
Obliged, ma'am.
So we are relieved that this is not a matter relating to third gender.
It's not.
We have heard it so many times that we remember everything about the case.
Yes.
Not including Nalsa judgment. That's why yesterday we asked you.
Yes.
Is it third gender? You said no.
Difference of the Obliged.
Nice to know. Yes. Lighter vein, madam, nothing. No offense intended, right? Lighter vein, we are saying. Enjoy the like this thing. Nothing. We have passed an order. Yes.
Wait, please, my lords. My lord, this appeal is against an order of the learned commercial court, dismissing, my lord, an application under Order 9, Rule 30. Last occasion, my lords called for the record because the learned, my lord, trial judge holds that summons were.
Record, madam. Record. Because we have to see whether summons have been served.
Yes, my lord.
That's the issue.
My lords.
Where is it? Find out summons have been served or not.
My
So
lord.
if they've been served, then you don't have a case. Not served, then of course it has to be allowed.
Yes, learned judge holds that summons were not served. And even the personal service, my lord, is not in terms of Order 5, Rule 9. Notwithstanding the fact, he says that we had knowledge of the filing of the case. Brings it under the second proviso.
Notice has been issued to the other side.
Yes, my lords.
Who appears?
My lords.
What do you say?
Seeks leave to appear through visa.
Yes. What do you say, Mr.
My lord, so the point what the appellant is submitting is under Order 9 and 13, saying that the service of the summons is not as per the provisions of the CPC. But the learned single judge, the learned district judge, he's pointed out clearly that it is not about the service of the summons or not. Whether as per the proviso, whether they have the information of the case filed before them or before the court or not is the important thing. May kindly see at para number 10, my lord, of the land
proviso. Like, so you before filing of the suit, you get a news item published and don't, sir, then say that they had knowledge about the institution, right? Something like that.
No, my lord, it is
Order 9, Rule 13.
13.
No, sir, his contention is the summons have not been served, right?
The learned, yes, my lord, that's a contention. Learned judge files
Where is
page 21.
which date, Mr. Which date the summons were directed to be issued? We will see the record, then hear him. Yes.
My lord, I will, for my lord's convenience, give a small list of dates when the sermons were issued and all that.
No, you tell us.
Yes. My lord, initially the suit was instituted, my lord, on 8/2017. Then, my lord, court ordered notice on 15/2/2017. My lord, on 2/3/2017, notices were issued to registered post.
Yes, Mr. Give it.
Yes.
No, so which date it has been issued, Mr.
My lord, summons were initially, my lord, issued on 15/2/2017. Then, my lord, court ordered, my lord, at second page.
What is this? This is all about this.
My lord,
So only this, we
in the third
feel
page.
that this chart, flow chart, etc. is wholly irrelevant deciding whether you are
Because
served with summons.
no, the relevance of it, my lord, they've instituted the suit against defendants unconcerned with, my lord, the injunction and the product which is sought to be.
No, with that we can't. We are only deciding
dates
whether
are-
the
yes.
court are
My lord,
justified in rejecting
Yes.
your application.
We're given in the tableau
So
below.
received the notice showing court 7/6, madam, see the order sheet 7/6/2007. Record of the commercial court has come or not? 7/6/2017. See, proof of service has been filed.
Yes,
It's a track record, my lord. They have filed that.
So after this thing, the restoration of the suit, no notice was served on you.
No,
That is, it should have been served on you. Mr. Yes, after only one query, please answer. After restoration of the suit, when was the notice served on the defendant? After dismissal of default on 20th August 2019.
My lord, in fact, the suit was ex parte made prior to that on 12/6/2017 itself, when they have not come. They have not appeared before this court.
No, after dismissal of the suit, Mr.
Yes,
Fresh notice ought to have been served to him and then he should have been set ex parte.
Yes,
That has not been done. So therefore, it has to be sent back.
with due respect, that part is not done because it is being made ex parte before that itself.
No, but after restoration of the suit, he is entitled to a notice. And that legal position perhaps you cannot dispute, though may not concede, but this is the position.
I'm not disputing that, my lords.
Yes, all right.
My only submission was that, ex parte was made before that, before that, and
Fresh notice, fine. All right, we are deciding it.
Well.
This commercial appeal mark the presence with consent of the parties. Heard finally, this appeal under section 13(1) of the Commercial Courts Act 2015 has been filed against an order dated 26th October 2022 passed by Commercial Court, by which petition filed by the appellant
You can read the read.
My lordship.
Yes.
The petitioner is a senior citizen who is a tenant of respondent number 3, my lord.
Tenant?
Tenant, my lord.
Huh?
He is a tenant of respondent number 3. Respondent number 3, my lord.
So, file an appeal before DRT. This is not forum. This is a measure taken under section 13(4) of SARFAESI Act, right?
Yes, my lord.
The tenant has no exemption. Any person agreed, and that period was expired.
My lord, he
And within 15 days.
We
If
are-
a senior citizen doesn't mean that he is exempted from all laws and everything. No, nothing applies. He can do whatever he feel like.
We are seeking-
You are putting a defense like this. I mean, what?
We are seeking,
He is bound by law.
time.
Senior citizen is also bound by law.
Yes, my lord, but he doesn't have knowledge about the.
So what to do? Yes, he should have to have had knowledge. We can't do anything. This period has expired, Mister. This notice was issued on 24/8/2023. Within 15 days, you were asked to. This thing, that period is long back. You have been sleeping over your rights, and we don't want to interfere. Satyavati Tandon.
We are seeking only
In
for
this
time, my lord, to reaccommodate.
This is not the forum. Not the forum. High Court under Article 226. We don't grant time to vacate the premises. This petition.
We're challenging the rules, my lord, of the Scheduled Caste Development Department Subordinate Service Rules, inasmuch as it provides for promotion to the post of Hostel Welfare Officer Grade 1.
What ground?
My lord, the ground being that the earlier rules, my lord, did not prescribe the BED, Bachelor in Education Department, Bachelor in Education qualification, my lord. But the new rules, my lord, prescribe that certain qualification, my lord. Petitioners, my lord, were appointed as Class 4 officers, and they were promoted to the post of Hostel Welfare Grade 2, my lord. When they were promoted, the only.
What is the interim relief you are seeking?
My lord, interim relief, although we are seeking, my lord, I don't think that may good. Yes.
Don't think it can be granted.
Yes.
Correct?
Yes.
We appreciate the stand, Mister. This is what is fairness to the court.
Yes.
This is what it is. Because you can't dispute the legal position, right?
Yes. Unless a counter is filed, I don't think that.
No, it can't be suspended rules.
Yes. Yes.
Cannot be suspended like this. We can give you 5 Supreme Court decisions in while rejecting the prayer.
Yes, my lord. That
But we appreciate that you have done it.
Yes.
Like you have conceded to this. What is heard on the question of admission petition is admitted for hearing. Also heard on You let them file, the
Yes, ma'am.
first notice will go,
Yes.
they will file counter,
Obliged.
then we will consider. You accept notice on behalf of everyone? Write her name, accepts notice. Praise warrant is granted 6 weeks time to enable her to file counter.
Deeply obliged.
Mr. Prabhakar, yes. Oh,
Earlier,
what is it?
sample court has been
They
directly-
did not file status report.
Yes, my lord. They
Why?
did comply the orders of the Honorable Court dated
Ah.
19/9/2023. Yes, my lord.
So what should be, according to you, what should be done, Mr. Prabhakar? You tell us, we will pass.
The guidelines of the national,
No, correct. They have not complied.
yes,
What should be done now?
again, your lordship may be given time to them to comply. That's only my humble submission before your lordship.
See, we are so this thing, right? We are asking. Yes, Mr. Why are you not this thing?
Well, it's two status reports are already filed, not
No, last date of hearing 19th of September.
filed, my lord. We have filed it, my lord, for response 5 and 9 and 4 and 8.
Do you know?
One submission. Only the IA3.
When have you filed?
IA3 only we have to file counter, my lords. As per your lordship's direction, my lord, we have filed status reports, sir.
No, this compliance report as per instructions contained in chapter 5 of
Yes,
guidelines
filed.
of national.
File, my lord.
You have filed?
Yes, my lord, I have filed.
No, ma'am.
I'll supply.
You have not supplied him a copy.
I'll give one.
When have you filed?
After direction of this Honorable Court, he didn't file any compliance report according to the chapter.
He's saying he has filed. What to do, Mr. We are.
just passed
When have you filed?
Last week, my lord.
Last week has 5 days.
He didn't supply us.
Date I am not able to tell. My lord. I've given copies.
See, Mr. Prabhakar, they don't even know the date of
I'm
filing.
very
of-
sorry for that, my lord.
I will take
Go
the,
through.
I will go through and I will come before your lordship.
Yes. Copy of the
One more submission.
copy of the status report, compliance report filed in pursuance of the order dated 19/9/2023 has been furnished to Mr. Prabhakar, learned counsel for the petitioners. Mr. C. Prabhakar, learned counsel for the petitioner. How much time?
1 week.
Learned counsel.
But as far as counter in IA3 is concerned, my lord, I request time, my lord, because
How much time?
2 weeks.
Weeks?
2 weeks.
2 weeks time is granted to file. 2 weeks time is granted to the learned counsel for the petitioner as well as learned.
So is requesting before this Honorable Court to come to file the counter, but not compliance report.
Complaints reports I filed, my lord. I just passed on
Counter.
Counter is
IA3.
Counter is not filed.
yes, my lord.
Filed, my lords. My lord, only IA3 I have to file, my lords.
They are saying that we will examine next week. If there is a-
Deeply obliged.
I'm deeply blessed.
They are quite sure about it, Mr. Prabhakar, that they have filed counter.
This is only to protect the children lives.
Yes,
Yes, yes.
Okay.
definitely.
The state also will do its best, my lords. Deeply blessed.
Yes.
May it please you.
Huh?
My lordships may recall when the matter came up last time. This is a matter where I'm an amicus of these.
So you had sought time to visit the
Yes,
institution.
I've
What have you done?
visited it. It's in a
Report?
very, very, very poor state, my lords.
All right.
Can I kindly draw your lordship's attention to the documents that I have now
The
filed?
copy has been supplied to them.
Yes, yes.
My lordships, I am appearing for incomplete petitioner. My lordships,
Fine.
my petition, as far as my petition is concerned, that is infraction.
No, why incomplete petition?
No, it is
You don't want that some facility should be provided
it
to visually.
is not the petitioner.
Nothing to do with these
I have
schools.
not, I have, myself is either blind school, my lordship, so I am agreed by the non-assistance of the government. I have filed this petition. Petition may be closed, my lordship. School itself is closed now.
My lords, his case is,
My petition.
I believe he filed an incomplete
They filed a
application.
IA1, you don't want to press it.
I am to
You have a counsel for the incomplete petitioner seeks leave of this court to withdraw IA1.
Page 15 of the paper book before your lordships. 15?
Then come to page 18. Says 16.
So this state government takes care of this. State government.
If your lordships come to page
State
90.
government. This is which place?
This is right near the about a kilometer from our high court.
No.
Blind boys.
Huh?
Blind boys.
So what this is?
The government for
Government. School run.
School run for blind boys.
What is the name of the institution?
The name of the institution is Government High School for the Blind Boys, Darul Shifa. Your lordship would find it at page 1.
So these have you, madam? Have you got it?
Just now I have received the report, your lordship. We'll go through with the report and
You go through the report and all this has to be done, right? I mean,
Yes.
there's no question of contesting it.
Yes,
This you have to file a compliance report
Yes,
and mark the presence income, learned Mike.
Appellant to lordship, we have filed an application. We filed our reply application, it's not only today.
What reply to the counter, madam? What substantial allegation in the counter? This is, madam, this is vacate petition.
Despite my vacate, we filed the August. Filed in the month of August.
No, you are the appellant, right?
We are for the appellant.
You are for the appellant.
They
So
filed-
you have filed, they have filed a vacate petition.
They filed a vacant step.
So you want adjournment.
Because counter is only served upon me today, 10:30 in the morning.
Learned counter to vacate petition. Learned mark the presence, learned counsel for Yes. What happened? It was referred to mediation. What happened? Today, learned counsel for the, you are for the petition. Yes, Mr.
Wait, please. My lords, these two contempt appeals are,
You have filed.
the report. He has filed a fresh IA.
IA.
Why?
Well, I may submit, my lord. The order, the report, if my lords were to peruse, and which your lordship were kind enough to,
Yes,
both
yes,
of us
yes,
to
yes.
have, appears to be inconsequent. They have not reached a conclusion, but they have recommended, my lords, in my IA, I have filed the report. They have recommended that National Remote Sensing Agency, which is very much in Hyderabad, will have satellite images of that construction.
Which IA?
The IA I have filed is IA number 2. IA number 2 is there before your lordship. That in that IA, my lords may see at page 13, my lords. Page 13 for a moment. Page 13.
13.
1-3.
Yes.
My lord. If my lords were to see at the bottom, analysis of the images of the site captured by satellite on various dates indicates the stages of progress of work. JNTUH does not have satellite. They're saying a satellite imagery will clarify the issue. However, JNTUH does not have satellite images and the facility to analyze the images to verify the progress of work on various dates. National Remote Sensing Center, Government of India, Hyderabad, may have the satellite images and the facility to analyze the images. That, my lords, is what JNTUH is.
May I get the audience again?
My lords, before that, my lord, this is what JNTUH appears to say. The reason for filing this present IA was that the Narsingh municipality, who is very much a respondent here, had
On that application, may I have my first word, my lord? He's filed an IA.
File counter.
Yes.
It's senior. Senior.
His application has nothing to do with the remote sensing agency. Remote sensing, I concede, my lords, let it have any.
Yes.
So far as the remote sensing is concerned, my lords, I'll have no objection because if that's, I do not want to give an impression to the court that I'm protecting somebody who's committed contempt.
Yes.
I don't want that happening at any cost. However, the present application doesn't ask for that. Kindly see his prayer in the present application at page 8.
In any case, you are.
I'll counting.
Submission.
1 minute. Let him file counter. No, Mr. Reddy. Why? Let him file. We will decide it, right?
If that is considered to by him.
Yes. But let him file counter that order. Yes. Learned senior counsel for the appellant. You are, let him file response. What is there? It's all a contempt only, nothing. Huh?
In fact, my lords, my argument will also at the end of it all be
2 weeks.
that after, if you need to do all this to come to a conclusion that there is contempt, that's good enough for my contempt appeal to be allowed. I don't think he has been instructed, my lord, passing him
All right, 2 weeks.
and they said that there has been construction
2 weeks.
in their counter.
Fine, let's stop.
The next matter, your lordship, I'm obtaining for second
Ah.
respondent, already stays there. Your lordship may kindly extend the stay.
Interim order
Both matters
granted.
were-
Yes, interim order shall granted in the, shall continue. Yes.
Obliged.
Till next year. Yes.
So, like.
Yes. Item 20, Your Lordship. Okay. Let me, Lordship, kindly recall that I was reading certain provisions of the Act to show me not the scheme of the Act.
Registration Act. Oh, where is the Advocate General? He is appearing. No, madam, Advocate General is appearing in this
I'll-
case. Yes. You don't know.
I'm appealing
You are a
for,
government advocate, no?
I'm appealing for additional advocate general office, your lordship, I'll call. I'm sorry.
Additional Advocate General office means nothing to do with Advocate General. I should be right. How do you call? She's saying I am appearing for Swedish. So you are associated with the Office of Advocate General, right?
Additional advocate general office.
Not nothing to do with Advocate General, right?
No, your lordship, nothing like that, but I'll inform.
Strange, right? We always thought it's one and the same.
State is one institution.
One institution, but they are they divided on the like she does. No, she doesn't know who is Advocate General. She is attached to additional Advocate General is her boss. She doesn't know who is the state
sorry,
government, how is it functions. Nothing, not bothered. Yes.
So in section 34, I was reading, not section 34 of the Registration Act.
Book 34. No, is he there or not? I mean, Advocate General,
I'll
where is?
inform it.
So can we take up? Otherwise, he will.
Yes.
Later on, he may ask for adjournment.
Yesterday,
Just I'll clarify.
So it's a part-heard matter, madam. Yesterday he was here. You were reading inquiry for registration.
Yes, inquiry, not 34,
Yes.
34-2.
Yes, madam.
So Learned Age is appearing. Learned Age is appearing in this.
He was here yesterday. So since he was not, you
I apologize.
should not seek any adjournment. That's why we ascertain. Yes. Yes.
Well, 34, my lord, I was reading, my lord. The sort of inquiry which is, my lord, to be conducted by the authority. A registering officer shall thereupon inquire whether or not such a document was executed by person who purport to have been executed, satisfy himself identity of the person appearing before him, and alleging that they have executed document. In case any person appearing representative to assign agent himself write such a person to appear. Any application of such a proviso under such so and so forward to the registrar whom it subordinate. Then Your Lordship, 35 is the procedure for the admission and denial of execution. If all the persons executing the document appear personally before the registering officer and are personally known to him, or if is otherwise satisfied they are the persons they represent themselves, if they all admit execution document, if in the case of the person appearing for representative, assign agent, admits the execution. See, if the person executing document is dead and his representative or assign appears, admits the execution, the registering officer shall register the document as directed in section 58 to 61 conclusive. To the officer, registering officer, again without satisfaction is recorded. Then without section 50, the 49 of the Lordship, just for my purpose, the consequence of non-registration, 49, your lordship knows. The no document required under section 17 or by provisions of Transfer Act 1980 register shall be affect any immovable property comprised therein, confer any power adopt, be received as an evidence of any transaction affecting such a property or conferring such a power, unless it is registered. This is section 49. And section 60, 58 is concerned, if the up to 58 or the procedure, what are the register books to be maintained, your lordships can skip. Then come to the 58 is concerned again, particulars endorsement on the document, how it is to be admitted with regard to registration and verification of the signatures, additions. Section 58 stipulates. Section 60 is a certificate of registration. That's a complete registration. Section 60 of the Act. After such a provision, section 34, 35, 58 and 59, as applied to any document presented for registration been complied, the registration officer shall endorse a registration certificate containing registered about it. But all this, I read only for the purpose, the authorities have only jurisdiction to verify with regard to admit execution, territorial jurisdiction, and other with regard to the regulating the procedures, rules have been complied or not. The question of title, question of prohibition, etc., is not envisaged under the Act, under scheme. The 69 is a provision which they rely for the purpose of sending the document making the rules. 69 of the Act. In fact, that that do not provide for taking rules with reference to section 22A. Section 69. Power of Inspector General or a Superintendent. The Inspector General shall, in exercise of general superintendence overall, a registered office in the territory and state of the government shall have the power from time to time to make a rule consistent, to make rules consistent with this Act. The rule 238, I brought your lordship notice forwarding that. In fact, such a rules framing power is not listed under section 69A to G of the Act. And your lordship, one or two other provisions with regard to refusal of registrations. On what grounds is the document can be refused to be registered? Section 71. When it authorizes every sub-registrar refusing to register a document except on the ground that the property to which relate not situated within its district shall make order of refusal and record reasons for such an order in book number 2, endorse the registration refused, and an application made a person executing claiming document shall without payment of unnecessary delay give a copy of reasons. This is one of the, if it is not territorial about it, and section 72, an appeal is provided. But in other situations where denial of execution is concerned, 73 provides for a registrar to refuse it. When a sub-registrar has refused the document, refused to register a document on the ground that any person or body by whom it purposed to execute or represented to assign denies its execution, or any person claiming a document or representative to assign or authorized or opposite may within 30 days after making so and so refusal apply for it. That's section 7. And 75, 76 the powers of registrar further reiterated. Every registering officer register a document except on the ground of the property which does not situate in his district that and the direct registration of service. Only on the ground of two grounds, that is, if person is not executed, if he is not in the territorial limits, these are only grounds for the refusal for registration. And section 17 contemplates, I already brought your lordship notice, the registration of all the documents which is to be conveyed, assigned, all documents above 100 rupees shall be registered by the statutory authorities. They have no power of refusal except the grounds stipulated in 71 to 76, chapter 12 of the Act. The two grounds which already have legal grounds which I have urged before your lordship yesterday was one is the arbitrary being the contrary to section 17 and the scheme of the Act, because it totally prohibits.
No, we don't know, Mr. Like you will have to support this proposition.
Yes,
that if one provision of the Act, 1 minute. What? Listen, Mr. You are, this thing, we have to test it. That's why we are asking you.
Yes, sir.
Very easy to say and get away.
No, I'll not get away. I'll not get away.
This thing,
I'll not get away.
what this thing? You are saying that if one provision of the act is contrary to another, it is necessarily, it is arbitrary. I mean, we don't know how. You are saying that it is contrary to section 17, therefore arbitrary. I haven't come across any such. Please tell me if any law saying that it is so that necessarily if one provision is contrary to other, it is arbitrary.
Contrary to other is concerned, Your Lordship knows the harmonious construction which is applied by the court is concerned, will not make the two provisions applicable in a harmonious way. The one of the interpretation is a possible. Otherwise, I'll come to that later after this submission, after this submission. What is the lead provision which governs situation? That is to be taken. In fact, Your Lordship very clearly the revised edition of the GP Singh have not dealt with this subject very detailed. I'll cite one or two authorities on that with regard to that harmonious construction. How if the two under the enactment in two provisions are contradictory each other? I'll come to that after my submission. Reasons why I say
because the submission is that it is arbitrary because it is contrary to section 17.
Section 17.
What is
scheme under the scheme of the act with regard to that? Because Registration Act, Your Lordship knows object is being.
And what is the other submission?
I'll just say the reasons why it's arbitrary, then I'll go with that. Other submission was already submitted yesterday was that why I say this more section 17 and 22 is contradictory is because of legislation. Yesterday Leonard AG said that he has got a presidential approval under Article 254(2). Well, according to me, the no consent has been taken. Therefore, the section 17 is a parliamentary legislation. Section 22 being the state legislation is a void under section Article 254(1) of the Constitution of India. So, I put it first, second round. Once I suppose if that approval is there, President assent is there, I will follow upon the first contention with regard to my thing about it. Because of repugnancy between the state and central legislation, my second legal contention was it is ultra vires and a void. Read with Article 254 of one of the Constitution of India. But why I say arbitrary is concerned, the prohibition takes away my right to deal with the property and transfer the property. First ground. This prohibition is totally permanent injunction in respect of right to exercise of my property. Permanently with regard to alienation, leasing, mortgaging, all the rights which I got under Registration Act and under the Transfer of Property which compels me to get registered. Even lease, Your Lordship knows 107 of the TP Act, I have to above 11 months, I have to get registered. Deed. All this Registration Act will, this prohibition will affect. Prohibition totally takes away my right to enjoy the property, exercise all the rights which I possess, which are part of the ownership. And thirdly, my submission is that, this state being a juristic person by itself, enacting this, giving an executive, as per the rules 238, whatever they framed under, staying under section 69 of the Act, forwarding the list by an executive fiat without any mechanism, saying that this is a blind property, state government property, central government property. Still declaring itself, adjudicating itself is the function of the court, authorities under the judicial forums. By itself saying that, it is totally declaring itself as a owner. That's why the prohibition is an arbitrary. It's a third ground, Generally, Your Lordship knows while reading section 22A, what small a consent I said, when there is an enactment like assignment or ULC, etc., there is a prohibition. State can prohibit the document provided an enactment, the transaction is illegal. Not simply saying that I am the owner, by itself declaring it and prohibiting it. That is It's nothing but not only separation of powers, not only adjudicatory powers, it is nothing but the executive fear without any mechanism. It almost amounts to deprivation of my right without due process of law. Article 300 of the Constitution of India. All these reasons, I say this is arbitrary. And also, the section your lordship have seen, section your lordship have seen, doesn't have any guidelines, nothing about arbitrary. How it is to be declared also, nothing, no guidelines. The full message. Advocate General State is relying on this judgment of the full bench. (2016) 2 ALD 236.
Hmm?
The Learned AG was saying that it covers it including Karoleka. Full bench has considered the validity. The it is left open. Your lordship may just see 49. Then I'll go to the paragraph, certain paragraphs for your lordship consideration. Page 49, your lordship. Page 49, your lordship. The whole section 22, it stood prior to its substitution 1927, struck down by batch of the following of the judgment of Supreme Court in Basatnatha so and so. In its application state of Rajasthan, we are making reference to this old section only to bring record impugned against new section 22 introduced in the place of old 22A of 19. It is also made clear constitutional of the section 22 of Registration Act is not a subject matter of the present reference. The submission was that it has taken into consideration of all these aspects of vote. Yes. Then the your lordship has just see para 2.3, 123. What is the reference before the Honorable Court? Order of reference. Page 253.
123. Para 123 is question was considered.
Yes, for 122 onwards. 120 on. With regard to A to B, 122 onwards, the question is considered. The question that
So this is clear, no 49, its validity has not been decided.
Decided, and they have, instead of that, they gave the page 156. I think lordship already seen that. Page para 156 various guidelines. 156. Number of guidelines. Instead of that, I'll just para 68, they approved that the Act guidelines sending everything is correct. Proceeded because of the arbitrary exercise of the rules, these guidelines have been issued para 156. Para 68 and 156 para 156 million. The authorities mentioned in the guidelines which are obliged to prepare the list of properties covered under clauses A to D be sent to registering authorities under the provisions relevant clauses. In so, class A concerned district collector shall also indicate the statute under the transaction and its registration provided further in respect of so and so, so and so. Roman 3, insofar as the paragraph 3 and 4 covering D properties are concerned, authorities contemplated therein shall forward so and so, so and so. Then Roman 4 is concerned forwarding list with regard to the registration of Telangana area. There is a change in the website shall be indicated in the same all concerned. 5, no notification contemplated under section 2 of section 22 is necessary. This is another pronouncement is that Roman 5, no notification contemplated by subsection 2 of section 22 is necessary with respect to the properties falling under class A to D of the subsection 1 of section 22A. The properties covered under the clause E of section 22 shall be notified in the official gazettes of state forwarded so and so, so and so. Then 7 is concerned, it will be justified in refusing document in respect of Roman 7. Respect of properties claimed by EAD and Section 22A provide authorities contemplated guidelines aforementioned communicated the list of properties prohibited under these classes. The concerned authorities also furnish list of properties or class A to D and the concerned registration follow the guidelines 2+3. 9 is concerned, it is open to the parties to document if a relevant property finds a place in the list of so and so, with A to D, subsection 1 of subsection 22, to apply its relation from the list of or a modification thereof to the concerned authorities as provided in the guidelines. The concerned authorities are obliged to consider requests to the proper perspective so and so part. The redressal mechanism under section 2 shall be a committee constituted by the respective state government and so and so. So this will not be honorable bench carved out the guidelines further over and above the guidelines under section rule regulation 238 etc. A committee to be constituted by respective so and so. Apart from the redressal mechanism, it's also open to the aggrieved person to approach appropriate forum, including civil court, for either seeking appropriate declaration, deletion of his property from the list so and so. Well, these are the directions at issue. And also observe saying that if the party concerned extract the list of so and so, A to B, receive registering on the basis of refuse receipt shall be furnished within 10 days from the date of application. Then 14 your lordship is the mere registration document shall not confer a title or a petty alienate the property otherwise to be so and so did not find a place in the list furnished concerned authorities. In such a case, already available authorities under so and so is to approach appropriate forums for relief. Well, these are guidelines. This is by virtue of these guidelines that whatever once when a list is forwarded, I am totally prohibited exercising my rights, and then my remedy is to approach the competent authority. In fact, your lordship knows even under the Land Encroachments Act, even in the Public Premises Act, if a state wants also summary only is not provided. In fact, your lordship, where a title is in dispute, long possession is there. In fact, your lordship, prevent the state or other authorities to establish in a competent forum of law. This is a scheme of things of the law is that a declaration of title is a civil right which is to be adjudicated with a state or a private person in a competent judicial forums. Whereas by virtue of these guidelines, etc., I have to forcibly have to go to this thing. Because of executive fiat, they set the list. I am forced to go to that without any consideration by any authority. This is worse than even exercise the power under the Land Encroachment or the Public Premises etc. Act. Such a power according to me is arbitrary. One judgment I placed directly on it, I could not get it, but however in a reference to other cases, 1998 8 SEC. There are 3 of these, I'll just read. The respondent in the appeal manufactures para 2 appeals agreed by the common judgment of Kerala High Court section 15 of the Kerala so and so Act is being invalid. Respondent appeal manufactures so and so the coppers of it, batteries, etc. So and so. Your lordship can skip then. The section is at 59A. Government to determine rate of tax. If any question arises, rate of tax levied in this act, sale or purchase, such a question shall be referred to the government decision, and the decision of the government thereon shall be notwithstanding any other provision in the act is a final. This has been considered by the court, from the paragraph 11 onwards. Plain reading of the section 59A shows that if any question relating to rate of tax, leviable act, on any of the grounds referred, government decision thereof, notwithstanding any other provision in the act is the final. This section does not indicate as to who can make a reference. There is no obligation on the government of here to deal in suicide so and so. In fact, we have noticed earlier by now, Omnibus order dated 23/484, government decided rate of tax payable in respect of areas without an opportunity being heardly having granted any delays. Lastly, section 59 clearly states the decision given by the government shall be final. There is no warrant in our opinion trying to read down the provision under section 15. Words said provision are clear, and our section gives absolute power to government to decide any question regarding tax payable on sale or purchase of goods in a manner deemed fit, and a finality against such a decision. Section 59 enables the government pass an administrative order which affects the negative statutory provisions of appeal so and so which have to be enacted. Decide the questions in relation to an order under section 15 passed, quasi-judicial authorities or a judicial determination stands replaced by the power to take administrative decision. This is nothing but a 15 debarrs the government in exercising the power even after dealer has succeeded the question reference ones. This power under 15 is so wide, unbridled, it can be exercised at any time and the decision rendered shall be final. It may well that effect that this would be such a decision even attempt to override the so and so High Court under section 40 of this section enables passing an executive order which has the effect of subverting scheme of quasi-judicial and judicial resolution of list between the state and dealer. Will it here a list between a state and a property holder? We are unable to agree with the submission that section furnishes a limitation with regard to power can be exercised. Section does not contain any guidelines at what stage power to be exercised. So your lordship can skip that. Then when it comes to 194, the aforesaid section itself provides question of determined so and so court fee. Commissioner direct determine fall and effective liability of the person in so and so commencement. Para 15. We are in complete agreement with the Kerala High Court. Section 15 Act is a violation of Article 14 of Constitution of India. Therefore, the right is striking down said provision. Opposite appeal is dismissed. Yeah. 190. Your lordship, how will defense statute? Two provisions in one statute.
That is not your case. You are relying on this. That
I am relying on saying that it is struck down. It is to be struck down. Your lordship, your lordship yesterday saying that if
no, we just said that harmonious construction. I mean, we are again asking you that you are not. This is not the. Mr. So far, you have not substantiated your submission that one provision of the Act is contrary to another provision of the Act. It is arbitrary under violative of Article 14.
Section. My submission was that section 17(1) will not provides me to shall register.
So this is what, like harmonious construction or what?
Harmonious construction will not, even if there is there, will not, so if it is not reconcilable, will not, the section can be struck down. That's all.
What
33 to 36.
33.
36, 44. It says
paragraph 33 to
36 and 44. My submission, harmonious construction not reconcilable in this case. And the section will not, my submission is from the beginning has been, the 22A prohibition, contrary to the section 17(1) of the Registration Act. The reasons I have given, what are the reasons I have given it, I need not cite one more authority which I thought, if a reconciliation is concerned, lead, if there are 2-3 provisions with regard to same subject with regard to that, a lead provision to be taken into consideration at reconciliation. Section 17 is Section 17 is a general regulatory provision which authorizes, facilitates registrations. That has to yield. In fact, there can't be any prohibition. The Act is in a regulatory nature. The Act doesn't decide the substantive rights. And this prohibition will not as a substantive right, state properties are being prohibited by itself deciding it. In that situation, I do not cite because the lordship want consideration with regard to that. The Supreme Court in 2004, Supreme Court case held the lead provision to be taken into consideration if there is a conflict among the provisions.
2004. Which
2015 4 SEC, page 421, 15 and 16.
You said 2004?
2015 4 SEC.
4 SEC?
15 and 16.
Page
421.
Para?
15 and 16.
What is it for?
If there are provisions or contradictory in enactment, the lead provision to be taken into consideration, which is general, which is will not satisfy the requirements of that object of the Act.
Oh, this he is giving the
16, Your Lordship.
So what lead, which is the, so you say that section 17 has to be preferred? What?
Well, section 17 has to be preferred. Section 17 registration has to be, this is object of the act is registration has to be done and it is shall. In fact, the statutory authority cannot refuse under the scheme of the act.
No. So therefore 22A has to be struck out. What? In view of para 16, 15 and 16, 22A has to be struck down.
I'm saying 72A has to be struck down with the reasons which I've spelled out, 4 reasons which I've advanced before Your Lordship, which is arbitrary. And it is contradictory to section 17(1), which will not entitle me to registration, shall be registered. Shall be registered.
What is this para 15 and 16 we are trying to understand? What
16 is concerned, Your Lordship, but referring, harmonious construct.
No, we just asked you a question, mister. That doesn't mean that we are not entitled to ask you a question.
Yes, certainly.
You are repeatedly referring. Nothing turns upon harmonious interpretation. It is not your case that it should be harmoniously interpreted. We don't know what.
I've never said that. So,
what is para 15?
16.
Harmoniously. So what, I mean, there is a conflict between.
However, if there is it's not possible.
Therefore, you are saying that there is a conflict between
17(1) and 22A.
17 and 22A. Therefore, 17. Then therefore 22A has to give way.
Yes.
Yes. Give way to 17.
Yes.
That's it. Yes. Anybody else? Yes, please.
May I please your word?
Yes.
I am appearing for petitioner item number 27.
Item
27, my.
All right.
My lord, my submission is that.
If you can first give your submission, then elaborate, it will be better.
I will allow. That
First submission is
section 22A itself is contrary and arbitrary in that nature, my lord. Secondly,
no, section 22A is what? Arbitrary.
That it is arbitrary and contradictory in itself.
Section 22 is arbitrary and contradictory.
My second ground is that, my lord, section 22A is repugnant to the section 17, 49, 71, 72 and
repugnant to section
17, 49, 71, 72, 73 and 76 of the Registration Act. And it is also repugnant and contradictory to Article 254 of the Constitution of
because
India.
presidential assent has not been taken.
Yes. No, presidential assent, even despite the taking the presidential assent also, there is some repugnancy in respect of the contradictory to the main provisions of the Central Act. Third one is that, my lord, it is the violation of Article 300A of the Constitution. This 22A is nothing but taking away the right of property even under 300A. My submission, my lord, these are only my grounds, my lord. Kindly see, my lord, section 22A. My first submission is that, my lord, this provision is not nowhere not mentioned. There is no non-abstentee clause is there. 22A, prohibition of registration of certain document. The following classes of document shall be prohibited from registration, namely Your Lordship, there is no non-abstentee clause is not there. It has not been prevented the authority to register the document which is presented under section 17 of the Act. And Your Lordship may kindly see the contradiction of 22A itself. Subsection 3, my Lord. Notwithstanding anything contained in this Act, the registering officer shall refuse to register any document to which a notification issued under class E of subsection 1. Here, my Lord, at E is E, Your Lordship may kindly see 22A subsection A, B, C and D is blanket prohibition. No guidelines are there. Whereas in E, any document or class of document pertaining to the properties, the state government may by notification prohibit the registration in which it owed or accrued interest of central government and state government, local bodies, educational, cultural, religious and charitable institution, those attached by civil, criminal, revenue codes and district courts and indirect tax laws and others which are likely to adversely affect these interests. For the purpose of E of subsection 1, the state government shall publish a notification after obtaining reasons for and full description of properties furnished by the district collectors concerned in the manner as may be
Where
prescribed.
are you reading? Where?
Subsection 2.
Ah.
Subsection 2 for the purpose of class E.
State
of
government shall
subsection 1, the
publish.
state government shall publish a notification after obtaining reasons for and full description of properties furnished by the district collectors concerned in the manner as may be prescribed. Whereas for the properties A, B, C, D are concerned, no notification is required, my lord. That itself is contradictory, my lord, and arbitrarily, simply because it is a property, it is the government property, it is the endowment property which is falling under A, B, C and D, it has been prohibited. Whereas for the properties of subsection E is concerned, subsection 2, a notification has to be issued. It is nothing but discrimination. Your Lordship may kindly see. Subsection 3 is concerned, my lord. Notwithstanding anything contained in this act, the registering officer shall refuse to register any document to which a notification issued under class E of subsection 1. For subsection E, properties are concerned, a notification has to be issued. And subsection 3, this subsection is commencing with the word notwithstanding anything contained. Whereas the main provision under section 22A is without any non-abstent clause, my lord. That is the reason Supreme Court has taken a, Honorable Supreme Court taken a note that while remanding the matter, they observe in the remanding matter, my lord, your lordship may kindly see the Supreme Court.
Where? There
Yes,
is
in
an
my
order of
immediate-
remand.
Yes, in the order of remand I have filed at my material papers, my lord.
This petition was earlier decided.
No.
Full bench, on the full bench.
Full bench decided. That full bench matter has been, in that remanding that full bench matter, the Honorable Supreme Court taken a note of this, that regarding section E and A, B, C, D and E. Your lordship, I have filed that order of the Honorable
Petition
Supreme Court in the
WP WP number
21187 of 2021.
Page
My lord, page 41. 41. It is a judgment commencing from, my lord. Judgment commencing from page number 56, internal page 16, my lord. Your lordship may. Page number 62. After issuing the above direction, the matter has been remitted to the bench concerned for considering other issue, including the validity of section 22A of the Act. The learned counsel for the state pointed out that the main issue pending before the High Court is the virus of section 22A of the Act. All the contention not sought to be raised by the
one
appellant.
minute. 1 minute. So there is no, the Supreme Court says that we further make it clear that we have not otherwise considered the matter on merits. Nothing.
My submission is that what I am making here, for making my submission, that is para 8. The submission before the Honorable Supreme Court is that the learned senior para 8, it is mentioned by lot, even though it has not been decided on merits and no, the learned
This
senior.
is para 8 is your submission, right?
That the same mechanism should be from A to D also. It is the contention before the Supreme Court at para 8. Supreme Court has recorded that. So that the same argument I am submitting before your lordship is that the mechanism, there is your lordship, there is a contradiction between the properties 22A A to 22A, small a, B, C, D are different. And the other mechanism for the is totally contradictory. My submission is here that, my lord, first of all, this
Article 14 is attracted when similarly situated persons are treated differently. Each
it is
clauses.
it is true, my lord. It is true.
True means Supreme Court says. We are not saying. Supreme Court says. So therefore, what we are trying to this thing tell you is that clauses A to D cover for a different scenario, and this 2 is a residuary sort of a provision not covered by E is a residuary sort of provision.
Yes.
And
My
we don't know.
yes.
Please.
My submission is that, my lord, this is my one aspect regarding that, my lord. This is the because that it has been the powers given under section 17, the scheme of the act. My learned friend also submitted that given under section 17, 49, 71, 72, 73, 76. Because of there is no non-obstant clause is not there to 22A, that will in operation, my lord. And that is the repugnancy between 22A and 17, 49, 71, 72 and 73. This is my submission, your lordship. Already my learned friend is, your lordship may kindly see, section 17 is totally clearly mentioned that all these are the documents are compulsorily registration is required. Section 49 says that if any document has not been registered, 49 also it is there, not there, my lord. 71 is the powers given to the your lordship may for a moment kindly see 41 of the Registration Act, my lord. Reasons for refusal to register to be recorded.
41.
71. Every subsection refusing to register a document except on the ground that the property to which it relates is not situated within his sub-district shall make an order of refusal and record his reason for such order in his book number 2 and endorse the word registration refused on the document and on an application made by any person executing or claiming under the document shall without payment and unnecessary delay give him a copy of the reason so recorded. Here, my lord, because that is the 22A has not been taken away the powers given under section 71 of the registration authorities are concerned, my lord. Simply saying that this document cannot be registered is given, my lord. That on the by virtue of that, my lord, by 22A, if somebody is going who is having the property for 100 years or the 50 years, simply the title has been deciding on the doorstep of the sub-registrar office, my lord. Your lordship may kindly see. Okay, 71. Your lordship may kindly say, see that, my lord. 72. Appeal to registrar from orders of sub-registrar refusing to register on the ground other than denial of execution, except where the refusal is made on the ground of denial of execution, and appeal shall lie against an order of sub-registrar refusing to admit a document to registration, whether the registration of such document is compulsory or optional to the registrar to whom such sub-registrar is subordinate, if presented to sub-registrar within 30 days from the date of the order, and the registrar may reverse or alter such order. My submission here is that, my lord, if I presented a document under section 17, it has been refused by the registration authority under section 72. A appeal mechanism has been provided under section 72. But if any document has been refused against the under 22A is concerned, my lord, the mechanism, we don't have any remedy to appeal the same, my lord. This is also have to be considered. The scheme of act is that presenting of document under section 17, refusal under section 71, and appeal lies under section 72. This is totally contradictory to the scheme of the Central Act, my lord. Yeah. '73 is concerned, my lord, application to register, where sub-registrar refuses to register on ground of denial of execution. When a sub-registrar has refused to register a document on the ground that any person, your lordship may kindly see, if section 17 I have produced the document, it is refused, 71 the appeal is there, and in respect of some other alternative remedy also is there under section 73. This 73 remedy also has been taken away by section 22A, my lord. That is also against. Your lordship, kindly see. Then section 76 I am requesting, ma'am. Every registrar refusing to register a document except on the ground that the property to which it relates is not situated within his district or that the document ought to be have registered in the office of a sub-registrar, or to direct the registration of a document under subsection 72 or section 75, shall make an order of refusal and record the reason for such order in his book number 2, and on application made by any person executing on claiming under the document shall without unnecessary delay give him a copy of the reason. So it is identical to the section 71, my lord. 71. These that 20, my submission is what I want to canvass before your lordship is that section 22A totally against the scheme of the act, and it is contradictory and repugnant with the section 17, section 17, 49, 71, 72, 73, and section 76 of the Registration Act, which is the central legislation. Your lordship may to what the judgment is. I have a thing. Your lordship may kindly see. Then, my lord, I am relying the judgment to support my submissions, my lord. I am relying the judgment of the Honorable Supreme Court, my lord, reported in AIR 2005, Supreme, page 3041. Already, my learned friend has. Rajasthan case, it is already submitted.
Yes.
My lord, kindly. My lord, I will read only relative paragraphs, madam. Here, the fact of the case is that Rajasthan High, there was also a 22A state legislation is there. Rajasthan High Court set aside the same, my lord. Against that, the state government has preferred the appeal. On the
Yesterday it was given. Yesterday SCC citation was given.
Against that,
yes.
the state government preferred the appeal.
Huh?
The fact.
77, right?
But I just now I supplied, my lord. I given it.
That was a different provision, right?
No, I am not. Ratio dissenting will apply to here also, my lord. My submission is that the ratio descendi laid down by this in this matter will apply here, my lord. I will read, I will not take more time, but I will try to submit and substantiate my argument. That is the reason I am relying. The para 10, my lord. The act was enacted to consolidate in act relating to the registration of document. May I read one? The provision relating to registration of document were scattered in 7 documents. The act was enacted in terms of entry 18 list 11 and entry 16 list 3 third of 7th schedule of the Constitution of India. It mainly deals with the necessity of getting a document registered in India so as to make them valid, and even if they are executed outside India, to provide for registration thereof after their first arrival in India. Section 17 of the Act enumerates the instrument registration of which is compulsory under the Act, whereas Section 49 encompasses the effect of a failure to registration. Registration of document, however, is not confined only to document relating to immovable property, but also for the document relating with other matter. As for example, adoption, Section 17 of the Act has been amended entirely by the state of Rajasthan. Thus, the state of Rajasthan, however, inserted Section 17(1)(f) and 17(1)(g) with effect from 18/9/89 and made the registration of agreement to sale and irrevocable power of attorney relating to transfer of immovable property in any way a compulsory registrable. Section 18 provide for optional registration of document specified therein. Section 22A provide for description of houses and land by referred to government maps or survey. Several state, however, as noticed therein, before insertion of sections 22A. In terms of section 22(1)(a) thereof, the state government have been authorized to issue a notification declaring that the registration of any document or class of document would be opposed to public policy. Subsection 2 of section 22A starts with a non-abstenter class. Here my submission. There was in Rajasthan amendment is concerned, there was non-abstenter class is there, my lord, stating that notwithstanding anything contained in the act, the registration officer shall refuse to register any document for which a notification issued under subsection 1 is applicable. Here, my submission, your lordship may kindly see. Section 32 occurring in part 4 provide for presentation of document for registration. Section 33 deals with power of attorney recognizable for the said purpose. Part 11 of the Act deals with the duties and power of the registration officer. Part 12 deals with the document which a sub-registrar may refuse, register which entirely are referred to a document relating to the property which was not situated within the district of the registrar or which ought to be registered in the office of sub-registrar or on the ground of denial of execution. An appeal from such order of the sub-registrar is provided for under subsection 2 of section 72. Even as against the order of registrar, a suit is maintainable. However, if and when a document is refused to a registrar registered by the sub-registrar in terms of section 2 of 22A of the Act, eventually no appeal would lie. Here also, my lord, no appeal lies. My submission, my lord, is relevant portion. Here the 22A introduced that, my lord, as a matter of public policy is concerned, my lord. In this judgment, the public policy also has been discussed, my lord, para 37 of the program. The word public, my lord, after discussing the act, para The word public policy or opposed to public policy inter alia find referred in section 23 of the Indian Contract Act, section 71B of the Foreign Awards Act and Enforcement Act 1961, section 31 of the UP, Temporary Control of Rent and Eviction Act 1947, and section 34 2B of the Arbitration and Reconciliation Act 1996. By reasons of the said provision, the judiciary has been conferred with power to determine as to the factors
No,
of
no, Mr. It may not be necessary because we are seeing 22A, there is no mention of public policy. So therefore, I mean, reading what is public policy may not be relevant. Section 22A does not use any where public policy.
aims and objects of the are not before your lordship. That is the reason I am presuming that it is under the public policy. That main act are not before.
Mr. You are challenging 22A object and reason it is for you to produce. Don't, I mean, this not relevant public policy. Because provision nowhere says public policy.
My lord, I am relying another judgment, then I will conclude. 1990, AIR 1992, Supreme Court, 1310, para 13, page 1310.
Para?
No, AIR 1992,
That
Supreme Court, page 1310.
Which para?
I will. My submission is that.
Which para?
6. Para 6. Regarding 254A is concerned, my lord. The appellant is assailing the validity of first provision to section 38 of the State Act on the ground of repugnancy under article.
It's concerned, Milord. I'm sorry, Milord. I said to the President, Milord, Advocate General has given Milord that 254 goes. He has given me the copy of it. I sent to the President as well. 254.
The appellant is assailing the validity of the first provision to section 38 of the State Act on the ground of repugnancy under article 254(1) of the Constitution, which provide as under 254, my lord, that is reproducing the article, my lord, in order that para 7, in order that article 254(1) may apply, two conditions must be fulfilled, my lord. These are the in the instant para 8, in the instant case, the Central Act as well as the State Act are both laws made in respect of the medical profession, which is a matter relating to, it is arising under entry 26 of the concurrent. The question, are the provisions of the first provision 38 of the Act repugnant to any provision of the Central Act? This question will have to be answered by applying the test of repugnancy laid down by this court in so and so judgments are there, madam. My submission is that, my lord, I am relying this judgment. Instead of reading, my lord, I will submit the summary of this judgment is that this honorable court is having ample power to test and determine there is any repugnancy is there or not. This is that this court is having ample powers to 254, test of 254 is concerned, my lord. Here my submission is that, my lord, 22A itself is contradictory, 22A1 is two contradictory, 22A3 subsection 3, my lord. My lord, this 22A is totally repugnant to the provisions and scheme of the Act, section 17, 49, 71, 72, 73 and 76 of the Act. Because of the 22A, here also there is a violation of the, my submission is, my lord, that the principle of natural justice is also attracting, my lord. Violation is there. Because somebody after 50 years of holding the property, he simply said that this is the government property or the work property in the year 2007 and 2008. without any opportunity to prove that he is the owner of the property. Second thing is that, my lord, under Article 3, the guarantee given under Article 300A depriving the persons from the right of property is concern also is affecting by virtue of 22A, my lord. My only submission is that this is my submission, my lord. Much obliged.
Item 21, 22, very same points, Milord, as already pointed out by learned senior counsels, adopt their arguments. Both item 21 and 22. Black.
Obliged.
Other members of the bar also, in fact, Mr. Venkatramana. There may be submission from the other petitioners, subject to lordship's work.
Nobody is there.
May I request, my lords,
You will continue on Monday.
yes, my lords, I will submit a note also for your lordships, my lords, so that we can minimize the time. My lords, it doesn't take much time at all, my lords. In fact,
all right.
Yes.
Learn it. Mark the present. Senior counsel for Learned Counsel for petitioners have concluded their submissions. Learned Advocate General prays for short accommodation. List on Mondays. What Monday is for further hearing. And send this. We will dictate the remaining part, whatever this 2 days. I've already PLN. I've already done. Stepler matter.
obliged.
Yes, madam. 27.
Wait. On the last occasion, I had circulated in this dates and events that will help me quickly go through the facts. Common order was passed in 2 writ petitions challenging denial of regularization of land, as well as a subsequent writ petition.
Regularization of
A land that was leased to the petitioner earlier and subsequently cancelled. That is one writ petition. When the order of status quo was pending, they went ahead and executed a lease deed in favor of R3 afresh of the same land. That is a second writ petition. Both the writ petitions are dealt with together and a common order passed. It has a long chain of history. Kindly see the events that will clarify to the court as to the lots of
yes.
Yes. From 1960, a garment industry was running in that. In 1967, a 99-year lease was granted to the petition.
It won't be concluded in 15 minutes, right? We continue on Monday. Same list will continue. 2 cases. Next.
For the respondent 1 and 2, Your Lordship.
Don't seek time, madam. After 14 years.
Seeking time, Your Lordship. Just I wanted to bring it to Your Lordship's notice that
Somebody has died.
no, Your Lordship.
That
Basing on the writ petition orders only, we have made taking an inquiry and issued the notices to the petitioners and passed an orders. Appellate authority has passed an orders by rejecting the plea, Your Lordships.
But they have not mentioned before this appellate authority, basing on the orders of the writ petition, we have passed an orders. Subsequently, they have writ appeal has
What it has been rendered infructuous. What are you saying?
my information is that it is infructuous because
Please examine.
because the writ petition in this
The first writ petition was questioning the non-regular. The learned judge said that the learned judge upheld the plea of the which is under challenge for this court will examine. Yes, some part of the open land was left out after allotment to R3. The learned single judge said the government may examine that matter of regularizing to the petition. Perhaps what learned DP says is that part of it they have passed an order. I have no idea about it. That party should be different.
Yes.
The main challenge still remains.
Okay. We continue on Monday. Yes. 29. All other case.
Apologize, Milords. Item number 29 for respondents, Milords. Respond number 3 expired, Milords. We are filing a memo to
Expired.
Milords. Respond number 3 expired.
Now, what survives in this? We are just. Respond number 3 is Hyderabad Urban Development Authority. Huh?
Milords, it's Suresh Lohade, Milords.
One of his other brother is on record. So,
There are why?
what have you done, madam?
Milords, we have filed a memo today.
No, not ma'am. You have the order passed by learned single judge.
Apologize for the just
See, nothing survives. They have to pass an order. There is a stay. Meantime, implementation is suspended. Yes. There is state. So, they have to pass an award now. If they didn't see implementation. Implementation. That's a basic. It is for the government to decide the issue that they don't want to decide. What their contention is, notification under 4.1 has lapsed because award has not been passed. See, the grievance is whether or not these cases that are not land have been utilized. Who is denying? How do we decide? This is a direction to issue notification under section 4.1. So what is your case, madam? You have not utilized the land.
I have to get instructions on that, Balaji. I apologize.
What instructions after this is 15 years, you are required to take instructions what you have been doing for 15 years. The prayer itself is to issue a notification under 4.1 and to finalize the process and above. So the signal is not given a finding that land has been utilized or not. This is whether or not the land utilized. It's a question of fact that how can it be determined? The signal. It can't be determined. So what memo means? You want to delete the name of respond number 3?
No, my lords. There are other legal heirs of respond number 3 to be brought on record.
They are already on record.
No, my lords.
His brother is there.
His brother is there, my lords. But there is
Brother is there. He represents the state.
My lords.
Don't, madam, start with this tendency of always seeking adjournment all the time. Somebody told you go and tell R3 has died, you have come here. No idea what is the case about.
I may be permitted to. I may be permitted to give the memo, my lords, because you filed it in the morning.
Learned counsel for the appellant has moved the memo stating. Yes. Yes. His other LRs are already on record, his brother, etc. this prayer made, you know what is the case about? Nothing, no idea. Huh?
We take them on Monday.
Why? Because you have no idea, right, about what is the case. What is, you are also sailing in the same boat, right? Like her, she also doesn't know anything. You also don't know anything. Ignorance is bliss, right? Learned Council for Respondent has filed a memo.
Obliged, my lords. Apologize, my lords.
Received. Call.
Item number 1.
Yes, Mr.
May I please, my lords?
Ah.
My lords, the petition before lordship was seeking admission in medicine, medical admissions, my lords. Under NRI quota, they could not apply earlier, your lordship. Both the petitioner, there are two writ petitions, my lords.
Page 21.
Yes, my lords.
You say so, right? Page 21 certified copy today. Yes. What is the other petition?
Yeah, same.
Page 21.
Yes, my lords. Page number same.
20, my lords. 20.
One is 20 and the other is what?
Disposed of. Certified copy today. Next.
Much obliged, my lords.
43. Disposed of today. Certified copy today.
Page number 19, my lord. 19.
19. Today. Yes.
Page number 16, my lord.
16.
Yes. Page number 19, my lord.
19. Done. Lunch motion. Any other?
Subject to lots of kindly, Miller. Two applications, Miller, in CS 14. Next week, your lots is kindly.
All right, yes.
Subject to CC number 1384 of 2023 had to be listed on last Friday, my lord. Next week, my lord, maybe.
Next Friday?
Next Friday. Obliged, my lord.
What do you want next week? All right, next week. Yes.
This matter, madam, today morning we have filed counter affidavit along with survey report, madam. Today morning, madam, we have filed counter affidavit along with survey report, madam.
Today morning?
Yes, madam.
Who has filed?
State government, madam, state, madam. It is written with some objections, madam. We will comply those objections, madam. Rush may take up this matter next week, madam.
My lord, only.
Ideally speaking, you people should be seeking adjournment. He himself is seeking adjournment.
My lord, he has served the counter, but he says that there is some corrections. Office has returned it, he say. My lord, I have only one submission. 13th, I have a difficulty, if possible on 20th.
Which date?
20th, next Friday.
20th.
We won't oppose. Only difficulty is we are worried about our dispossession. Let them conduct, they are saying they are conduct now, their counter, what I find from my friend's counter is that Russia will see.
All right, 13th, I'll make myself available or the other, they will make other arrangements.
Even for 13th also, I would make the same submission. Not that if my friend has inconvenienced, what I will be the last.
Yes, yes.
I can't oppose. The only thing is I would say request.
See, Mr. If so long you have been able to maintain your position, there is no reason why for another week or 10 days you can't be. 20th, mark the presence, learned counsel submits government advocate, whatever, submits that he has filed, he shall file the. We will take it up. So in case for some reason it is adjourned, then we will definitely consider grant of interim order. Yes.
May I please, your lordship?
Yes.
Here the petitioners, there is a threat of disposition and demolition of the houses of the petitioner, your lordship, where they are living peacefully in the dwelling houses, which is the part and parcel of survey number 57.
I've got respondent number 5. I need to find the function.
My lordship, page number 99 to 110 photographs we have filed, your lordship, where there are 100, 200 people are coming, the police, and creating barricades around the houses of these small houses.
None of the petitioners have titled. Ask him.
Sir, you have title on the subject property, any of the petitioners?
Yes, your lordship, here the respond number 124 is from the 60 onwards is agitating. Peaceful position, your lordship, we are the peaceful position.
Did you file any document substantiating your title?
The electricity bill and water bills and documents we have filed, your lordship. And page number 83 to 89, your lordship. Here we have filed the documents, that is unissued documents. My humble submission, peaceful position.
You know what peaceful position, right? What is again this query which brother has asked? What is this? What is your title? Any electricity bill is not a document of title. Water
We are
connection is
paying
not a
property
document.
taxes and our application is pending with the government for regulation, your lordship. So my humble submission, we are.
Are they in possession? No, what do you say? They are not in possession.
Advocate Commissioner report also find our position, your lordship.
Let him file counter.
Until the status quo, directed, your lordship.
What status?
Otherwise,
Without arguing. Without arguing status quo.
Because police is involved, your lordship, in dispossessing us. That is the.
Police is involved?
No, my lord.
No.
Photographs are seen, your lordship, for police.
We have received 100 days call, we went there. He has taken the photographs and filed the photos.
Huh?
We have received 100 days call that some
You have received what?
100 days call.
100.
Emergency call.
Emergency call.
He went there. He has taken the photographs and filed the photos.
Oh, which page? Page?
From 99, man.
89?
99.
19.
Even on 4.
Particularly 105.
99 is some other person, not police officer, somebody leader addressing a gathering of some people.
Subsequently in 105, 106, and your lordship, page number 112, your lordship.
One not?
105, 106.
Where is police here, Mr.?
In 110 is there, your lordship.
So police.
108,
Huh?
108 page number, 106 page number.
Page 106.
1 minute. One. He is standing busy with his mobile. Police officer not even bothered.
My lordship, 112 page number, your lordship.
It must be interesting. This thing, watching an interesting some video on his mobile. See how engrossed he is. Not doing anything. He's standing near the tree, under a tree.
Page number 112, your lordship. Where not the finding is there.
No.
Page number 112, your lordship.
108. There's nothing like he's standing there.
My lordship, they are
There's nothing to suggest, Mr. That.
Your lordship, page number 112, the Tahsildar report, your lordship, which states that, may permit to read, it is to submit that as per the location sketch, as per the boundary shown by the Mandal Revenue and Kukutpally Tahsil of the subject land sub 57, obit, it is found, notice that 21 residential ACC rooms.
So, is there any proceeding initiated against them under Encroachment Act, if supposing if they are encroachers?
The 3070.
Huh?
When you are not disturbed.
So therefore, how can you throw them out, supposing if they are encroachers? Just a minute. Listen, I mean, the two constitution bench decisions and even not the Supreme Court has said time and again, right from 1968, that even if they are encroachers, they have to be thrown out in accordance with law. Initiate a proceeding, get an order, execute it. But you can't that is what is.
Violently bolder to the extent of 720 meters.
No, but what is this thing material to show that they are?
Contented by them right from 1968.
Let him file counter. Let him file counter. Let him file counter.
Mandal Survey report is there, your lordship, which finds my position. Kindly permit to read your 112 page number.
Which page?
112. 112. That's the last paragraph, your lordship. Which is the report of Mandal surveyor, that is.
Joint inspection report.
Yes, your lordship. Where it is to submit that as per the location sketch, as per the boundaries shown by the Mandal surveyor of Kukutpally Tahsil of subject land, survey number 57 in O bit. It is found, notice that there are 21 residential ACC rooms, in which 15 residential ACC rooms are which compound wall. Further, there is temporary shed, few demolition mobs, 2 common roads, and one side of subject land is bounded with the sheets. Subject land comes under CS 758, your lordship.
So this is the government land belonging to the government. This itself 112 read government lands, Mechal, Malkajgiri district, Kukatpalli Mandal.
They are throwing away due process opportunity given because
what opportunity?
Because
You are rank encroach upon anybody's
No, you are actually
property and say that opportunity. What opportunity?
in the another that is a writ petition, Your Lordship, that this honorable court has
No, but they are this thing, Mister. They are saying that you are let him
not to dispose. That's all.
no, nothing. Not to let him file counter. Then we will consider. He is saying that you are not at all in possession.
Like possession and protected, Your Lordship. Otherwise, all poor people, Your Lordship, they are. 15 houses are there. Police are kidnapping even the women also they're taking in the Innova van.
No. What
Yes, Your
kidnapping?
Lordship.
It's a serious this thing,
Yes,
right?
Your Lordship, there's a.
And so did you file FIR against police officer who is kidnapping
Yes, Your
women?
Lordship, there is a writ petition filed. In fact, yesterday we requested to track
No,
the
Mister,
matter.
don't like. I mean, just for the sake of it, don't say anything. Whatever you feel like, it's a serious thing.
Yes,
Which
Your Lordship.
police officer has now filed an affidavit? Which police officer has
We have
kidnapped
filed
whom?
CC footage are there with us, Your Lordship. CC footage.
But that is not the subject matter of this writ petition, right? To
Yes.
register FIR against the police officer who has kidnapped anyone.
No, my humble
This is not the
submission, how they are
don't
compelling to
say.
vacate the houses. Same 57 survey one matter that also.
Huh?
There is no amendment in the entire activity.
Huh?
The police have 300 acted.
So what we will say limited extent. The structures situated in this 112 shall not be demolished to the we don't say anything about positions. To the extent no, the structures mentioned here. We do not recognize petition's position. We will say that these superstructure, right? This ACC so and so will not be demolished. Otherwise, if we say that they are in possession, then they will get creating right now. All right. Heard on the question of admission. Notice on behalf of respondents 1 to 4 is 1 to 4 is accepted. So and so 5 and 6 on caveat. Issue notice to remaining respondents. How much time do you want? Learned counsel for respondent 5 and 6. Yes.
Matter pertains to non-registration of mortgage deed in.
Yes. They're coming up several times.
Yes, Milord. Last occasion, the Lordship directed me. TSHC.
As we have filed counter private.
Nothing. These are the subject matter is covered by 14. Whether his name has been reflected.
IA1 of 23. Lordship directed me to implement the JHMC. Who is the
So where is Mr. Standing Counsel for 5 and 6? Nobody is appearing.
Nobody. 1 of 23, Milord, Lordship. IA1 of 23.
1 of 23. Yes, madam. 1 of 23.
For implement of JHMC.
All right. They have been served, right?
Yes. Along with this, Milord,
No, you have served them, right? Nobody appears.
The name of the standing council also printed, Milord, in the call list.
So we'll allow this IA, heard on IA 1 of 2023. Despite service of notice, none has appeared on. Despite service of notice.
Last time the application was recalled. The name of my colleague Vadendra Joshi has to be printed. My colleague's advocate on record is Vadendra Joshi and Mr. Palla Ravindra. That order was recalled.
Yes.
Before I go into minutes, I think these matters have to be placed before a learned single judge because review application has been there. The facts are this, OSA were heard by division bench. Both the learned judges differed with each other. Then the matter was referred to third judge under section 98(2) of CPC. The third judge took an opinion, formed an opinion, gave a decision. As per the standing orders, the matter has to come back to the revision bench and division bench has to pass an order in accordance with the majority. Meanwhile, I already filed a review application. So review application, review is filed against the order of the third judge. So therefore, the review has to be heard by a single judge.
Who has passed the which?
Justice Ashutosh Mohan, the lordship then was. There is no more act on it, no more. It will go before learned single judge.
No, but in view of order passed by division bench, what survives in your review?
Two judges differed, my lord.
No, correct.
Section 90 went to third.
So you are saying that if he third judge should not have agreed, he should have concurred. Supposing
yes, my
something like that.
With one particular, not with the other judge. That's what my review is, my lord. I have given certain grounds, my lord, saying that this is how it is an error happened on the face of the record. But that decision has to be taken by again a single judge only. If it was the same judge, it would have gone before the same judge, learned judge. I was, my lord, whom so your lord's Prasan as the chief general administrator, the master.
This matter is even if it comes to the single judge,
See, this matter arises out of CS 14. Even if it is referred to single judge, it will come back to the bench again.
But it may arrive as CS 14. But it was against OSA was filed against our application 754 where delivery of question was being directed. Then OSA was filed. One learned judge upheld in matter gave the finding my fair other. But even the CS 14 related, the review which has been filed, the review is in respect of a third opinion, opinion of a third judge. But unless and until the third judge reviews his order, a division bench cannot pass an order. Because ultimately the 98(2) as well as order, your lordship may take 98(2).
Now, which is the order of which you are seeking review?
331, page number 331.
Order dated?
Dated 7th February 2012.
2012?
Yes.
Which case he has passed this in?
OSA, all the cases. OSA 18, 19, 20, 21, 22, 23, 24, 25.
Of 2004?
2004 and OSA number 31, 32, 33 and 34 of 2011.
Okay. Technically, this application has been filed seeking review. Which 15? 250. Yes. Huh? Copy today. Hmm.
360, 317.
I appear for the respondent writ petitioners.
I filed impleading options pending. I filed impleading the writ petition, my lords. My lords,
May I just say this? The order of the learned single judge is appealed by the state. It is an appeal filed by the state which is before the honorable court. And for the appellant state, they have to make out their submissions. I have submitted a brief synopsis of 2 pages.
I have filed an application on 31/8/2020. Wherein I stated that the subject matter of this appeal delay is seized by the Honorable but the Supreme Court, this matter is periodically heard and the further date is given. And this also sees appeal delay.
This is
final judgment comes from Supreme Court. And matter will be heard accordingly.
But probably as we distinctly, you are opposing that, as I said, nothing to do.
Last occasion, Your Lordship.
So you will have to tell us what is the Supreme Court order, how
Yes.
this is identical, this.
This matter is also pertaining to the appeal.
There may be several matters.
Yes. Well, at CS 40. Contains.
What is the write-up, what has been done? We have not read it, Mr. We don't know what is the case about. What is the?
Case of the petitioner before the single judge. This matter, well, they have made an application to the MRO. MRO, my lord, is not trying to mutate the properties in their favor.
Application for mutation made to MRO.
Yes. My lord, this was refused on the ground. On the ground.
My lord, I have prepared a small synopsis, my lord, kindly have it. 1 page only.
On the basis of the privilege.
We were reminded, Supreme Court imposed recently, you must have
Not
read
exceeding 2 pages.
No, Supreme Court imposed passed on this thing, counsel for filing a synopsis running into some 50 pages or
That
something.
is so. That is so.
Well, it's not that, we just remembered like you.
I filed it in the registry also, my lord. USR number is also there.
Yes. They imposed cost of 45, 50 pages, something. Synopsis. Huh? So one appeal is by the government, the other one is by?
They, two persons have filed implement application saying that they are also.
No, one appeal is by 579. Who has filed this double one?
We have filed, sir. The person.
Who has filed the appeal? Okay.
The whole case of the petitioner, the writ petition and the respondent here is that they have a rights accrued by an order dated, criminal degree order dated by 23/6/1963. That was the preliminary degree that was issued on the basis of which they are entitled to have a mutation in their favor. But this honorable court, has also for certain time 2003 and 4 upheld their rights. Ultimately, Supreme Court said, on the basis of the preliminary degree.
No, Mr. This joint collector has granted mutation.
Yes.
Joint collector.
Yes, that has been cancelled.
Cancelled? When? Have you gone through this?
This property, I invite your lordship, even as per the amendments made by the respondent, your lordship may kindly come to the page number 30 of the material filed along with the writ appeal.
See, Mr.
Yes.
You know the facts, right? Yes. There is an order. 1 minute. 1 minute. There is an order we passed by the joint collector directing mutation in favor of writ petitioner, and as it has directed Tehsildar to implement the same. So he wanted implementation of this order, which was not done. He filed a writ petition. Learned single judge said that, and he wants mutation of his name in revenue records, and this is an order 6/5/2009. Until unless it is set aside, I mean, this sort of a direction appears, prima facie appears to be consequential, subject to what you argue.
Yes. These are the properties, just for the purpose of convenience.
No. What is the answer to this?
Answer to this.
6/5/2009 order is staring at your face, passed by joint collector.
That order has not been implemented.
Why?
That purpose, the writ is filed for the dealer. Just the lordship may please to give the
Yes, of course. No, we are only interacting, Mr. When we put you question, that doesn't mean that we are preventing you from argument, so that the debate takes place. We must tell you what is going on in our mind. So we are telling you, this is, you argue whatever you want to.
These properties will are involved.
But you also answer the query. You argue whatever, but please first answer the query, then argue whatever. So order dated 6/5/2009, after remand has been passed by the joint collector, granting mutation, right, in favor of the writ petitioner. It was not done, therefore he filed a writ petition. The learned single judge has directed that it be done.
Yes.
You are in appeal against that order. So the query is, until less the order dated 6/5/2009 passed by the joint collector is set aside by some forum, the consequential direction, how can you find fault with the consequential? That's the query. Please answer.
As of now, there is no final. The entire case before the learned single judge, while directing us to mutate their name on the basis of their primary degree. For that purpose, my lord, your lordship may kindly see, even as the order passed by the MRO, I invite your lordship's kind attention to page number 37. This I invite your lordship's kind attention to.
What is the date of order?
Order dated 5/11/2004. 14/11/2005, my lord.
This has been allowed. This was allowed 14/11. This has been set aside.
Yes. This set aside and directing us to say this itself is illegal.
No, this was said, Mr. Additional AG. This is what we are trying to tell you. 14/11/2005, Tehsildar passed an order granting mutation. This order has been set aside in revision on 6/2/2007.
Yes, 14/11/2005 order was restored,
Was set aside.
set aside, and the mutation was restored.
Ah.
That the properties were directed to restore.
Then there was an order dated 15/12.
Yes, 15/12 order is also there, my lord.
The matter was
Page number
remitted.
69, my lord, your lordship may. Page number 69. Fifteen 2008. There was an order passed by the honorable court. High-level 2004 order. This honorable court by learned single judge by order dated 15/12/2008 at page number 69 directed remanded matter and to consider.
So after remand, this order has been passed. You have not given him this synopsis.
I have given, my lord.
Please see, Mr. This additional AG, please see this synopsis, which you will get everything. He just now given by him.
Because
facts have been stated. So you see, item entry serial number 2, 14/11/2005, then 6/2. This all you are telling 15/12/2008. Thereafter, the order passed by joint collector after remand.
Milord, it seems, my lord, petitioner has not filed this.
No, it is circulated, it is, USR number is there. I'll give one more.
Not filed, you have copy.
Yes, I have.
He doesn't have extra copy, give it to him.
Yes, I'm giving, my lord.
Please have, just Mr. Please have a look at this. This is what you are trying to tell us.
That's 6.3 an order.
So 6/5/2009, there is an order.
It's an order. Page number 70.
That's what we were asking you.
74, your lordship.
So.
Yes. Accordingly, the case was taken on. File and notice were issued. This is the order of joint collector. I want to narrate the background story of this.
You can smile, right? Nothing prevents you from smiling, right? You can smile.
Matter
Yes.
boils down at the point. How entire matter boils down at the point. How they have rights approved for the mutation is the question. They are clearing the properties. When I am reading the order dated 6/5/2009,
Yes.
the facts of the case, the facts of the case are in brief, as awaited.
This, see the operative portion.
Yes.
Honorable High Court has passed to as per so and so, page 77.
The direction of the Honorable High Court in Petition 7861. Dated so, the government order in memo number so and so. Sirlingapal Mandal is hereby directed to take necessary action under the provisions of Andhra Pradesh in Land and Water Hospital Act 1971. Citizen petitions accordingly disposed of. These properties are properties involving CS 14.
So,
CS 14, there was a preliminary decree dated 28/6/1963. They claim the rights approved to them.
That you have preliminary decree dated
28/6/1963.
So the final decree has not been passed, therefore their name cannot be mutated. This is the argument, right?
On the basis of the criminal decree.
Name cannot be mutated, even though your officer passes an order. But what action have you taken to challenge this order?
Even though that criminal decree is in between the private parties for partition. These are the properties at stake. And that was the decree for partition, which is not a declaration of title. Therefore, no rights are protected them. This matter has gone to Supreme Court. But if your lordship permit me to read the judgment of the Honorable Supreme Court, I will take your lordship to the judgment of the Honorable Supreme Court in respect of this CS 14 only.
We are hearing you with all patience.
Yes.
Why do you say that we are not permitting you to argue?
Your lordship may
That doesn't mean that you will read 150-page judgment of Supreme Court. This is the dispute is only with regard to this land and about the order. This 6/5/2009, you must understand, Mr., has not been challenged by you. This order operates. The writ petition was in substance. Try to understand, right? In substance, seeking implementation of this order. That is what learned single judge has done. So this is some all properties are pending before civil court, Supreme Court. We don't know then what we are doing in here then. If everything is pending. What is pending?
This matter pending in respect of CS 14. Just for that purpose, just I invite your lordship's attention to judgment of the Honorable Supreme Court that I filed along with my writ petition. This also covered by the Supreme Court judgment.
What judgment? So this order has been set aside by Supreme Court.
Not set aside. This entire properties, this entire properties pertaining to CS 14 on the basis of the legal degree are why? All the property. Yes, I will. Yes, I invite lordship.
No, again, but Supreme Court means you will have to tell us background, right? Any Supreme Court judgment will not easy a party to that Supreme Court.
Party.
But
he has.
How it has arisen? Tell us.
Yes, they say lands in appeal. No boundaries, but demarcated. The survey number.
No, they means who, Mister? They means who?
Respondents here before your lordship.
No, you are saying that it is covered by Supreme Court.
Yes.
So before that, you will have to tell us how matter reached Supreme Court, whether respondent was a party in the proceeding, how or it was it a petition under Article 32 or SLP under 136, who filed the petition, what happened?
The Supreme Court matters have gone to Supreme Court in SLP.
Against which order?
Figure 14 in respect of Hyderabad. When those matters have gone, Supreme Court had meticulously dealt with the all matters in respect of.
Mr. Who filed a petition in the High Court?
Supreme Court they filed Trinity Infrastructure.
No. High Court, who filed a petition? What happened? What was under challenge? Whether the order dated 6/5/2009 in favor of appellant respondent was challenged in writ petition. What happened?
This is not. I am not saying that this 6/9/2000 order is under challenge that matter.
So therefore, you must tell us what is the writ petition?
I am telling the background of that case is. They claim.
They means again who? They means respondent.
Partner to the litigation. Just I invite your lordship's kind attention to the.
Where is the order passed by the writ High Court?
Just I am inviting your lordship's attention to the Supreme Court judgment, wherein these office-based lands have also been discussed at length, in which a part of land they are claiming. These lands in respect of office, but also dealt with.
Hey, Mr. But you must tell us what was the writ petition, then what then we will appreciate.
That's discussed. That is discussed.
Discuss.
Along with additional affidavit, I filed it. Page number 28.
Doesn't have a case.
Page number 28, Malak. At page number 30, this background of this litigation, not now litigation, 1958, this litigation has.
Hey, but the petitioner is not party, respondent is not
party. The lands which is claimed by the petitioner are covered by the Supreme Court judgment.
That is what.
Covered means what covered? That nobody will touch the revenue record. This is the order.
I invite your lordship's kind attention.
Mr. You are additional advocate general. You are not answering. This civil appeal was filed against which order? What was, who filed the writ petition? What happened there? Please tell.
In CS 14, there are, just your lordship may please.
Common rendered judgment intra-court appeal. Batch of intra-court appeal.
Just directly I drive your lordship. Paragraph 46 of the Supreme Court judgment.
No. This is Mr. This read para 4 first.
Yes.
What we are asking you, you understand, you are an intelligent person. But at times when we don't have a clear answer, this is what we do. Read para 4.
Agreed with the common judgment rendered by division bench of the High Court for the state of Telangana in a batch of intra-court appeals, confirming the judgment of the learned single judge of the High Court in a batch of application in a civil suit. Various parties, including the state of Telangana.
What we are asking is, what is the order passed by learned single judge? What was the order which was affirmed by division bench? And then how matter went to Supreme Court? What was the subject matter?
I will place those orders for that next week. So this order, my attempt is to.
No, Mr. But you must give the background in order to, because see, we have to eventually hold one way or the other. Either this Supreme Court decision applies or it doesn't apply. Your case is, Mr. Listen.
Yes.
Your case is that since Supreme Court, this subject matter of this writ appeal is covered by judgment of Supreme Court in this SLP. So therefore, the appeal has to be allowed. This is argument.
It's not. I am trying to how the judgment of the Supreme Court is applicable to the case on hand. That is what my attempt to my lord.
So therefore, this appeal has to be dismissed, right? Appeal has to be allowed. What is the submission?
Yes. Just for timing, my lord, just I invite your lordship's kind attention to paragraph 46 of the Supreme Court judgment.
Brother, you are getting it.
Paragraph 46. At page number 53, my lord. Page number.
Not partition. Not.
May if your lordship permit, I read it, my lord. Then I will.
No. So who has again para 4? Read, Mr. Para 4. Again read. If you are not getting, Mr. You are an intelligent person. You have argued several matters before us. We know that you understand what we are asking. What was the order passed by learned single judge? What was held in intra-court appeal? Who went to Supreme Court? Simple. Before reading para 46. You tell us.
In few seconds.
Who filed the writ?
In the order,
Who filed the writ petition?
Supreme Court referred to the order of the learned single judge is that, my lord, I sub.
Which order?
That
order dated.
What
is writ appeal?
I will, I get it and place before Lord. Next Friday, your Lordship may take it. So I will find out. Supreme Court referred to a single order, single bench order, and division bench order, which deals with the fact and law in respect of CS 4. CS 14 is the entire gamut and its entirety deals with whether a particular person is accrued any right on the basis of the privilege degree or not. Supreme Court harshly came down and said, well, I should not say, well, what Supreme Court said here.
You should say why.
High Court invented its own procedure, regardless of the CPC and any law into Constitution. High Court is gone oblivion.
This is you are taking an occasion to criticize us in respect of a subject matter which is to which petitioner is not a party. What is this thing? Where this Supreme Court has said you have challenged the order of single judge before Supreme Court. This is the subject matter of this appeal is we have to examine the validity of the order.
Well, your lordship may take it next Friday. But I will get all the orders.
Simple thing, right? You know what is it?
See, once looking to paragraph 46.
Deliberately, you are not telling us what is the order passed by learned single judge, what happened in writ appeal. If anybody can assist, please. This is the, I mean, they should be plea, we have to seek assistance. So we can reject it by saying that he has read paragraph 46, respondents are not parties, but we don't want to do it. We can reject your prayer and saying that Supreme Court has criticized, that does not apply to this decision of this intra-court appeal. There is no question of devising our own procedure. The power is conferred on the division bench in accordance with clause 15 of latest patent. Law confers the power to hear the appeal, which we are doing, devising our procedure. Your officer has passed an order. And that order has attained, you understand, mister?
That's true.
Somewhere, some thing has to be done, merely because somebody is behind the scene. You cannot, this thing go on opposing whatever, pretending not, we know you have argued so many cases before us. You are an intelligent person to understand what we are asking, but you have your own, we are not asking you to concede, but you should understand what question, please answer.
For the purpose of persuasion sake, my lord, I was submitting some points.
Additional Advocate General, after arguing the matter, be more prepared.
I am here to assist.
Yes, that's the, should be the spirit. Yes. Next. Yes, mister. Appearing for whom?
Stay.
What is contempt appeal?
No, my lord, these are the first appeals arising out of a suit. And the suits are the offshoot of a CS 14.
So?
My lord, the first appeal is prepared by the government, my lord, challenging the decree and judgment wherein, my lord, the declaration of title basing on two aspects, my lord. One is the land acquisition proceedings and the second one is possession of the plaintiffs. Basing on that, the title has been given.
Yes, then.
May I request you that? May Lord, these papers are served last time, my Lord.
Synopsis, my lord. Synopsis, my lord. There was.
They are the appellant, they will have to argue the case.
To go through it and then answer. Oh, Lord, should make you some time, reasonable time.
11 years, mister. We don't want it to be held. No. This is for our benefit, not for you. Because we have to write judgment.
No.
It has been so easy to give this all files to you. We would have prepared the judgment and we would have signed it. It's not so. This is for our assistance, mister. Let him argue today, it will not be concluded. Your turn will automatically come the next day, you go through it. He will not conclude it today. Let these hearings, someday it has to begin. 11 years, mister, someday.
There are two more appeals.
Yes.
Corrected appeals are there. I don't know, they have not given anything, anything there.
Two appeals?
146 and 150, CCCA 19. They are also there along with that.
146 is there.
I explained that, my lord. Two suits were filed.
No. What do you want to say?
The defendant, my lord, they have referred two appeals that are the last two matters. The first two matters.
It's listed, no?
They are in the list, actually. But nobody is appearing. That's why I'm asking whether they are giving any note also, so that we will also know it.
No, you are doing.
I am not on that, my lord. I am only for the government, my lord. They are the private parties.
So whatever will happen, right? Nobody is appearing what the order 41 rule 19 provides. You experienced enough to know what the court will do. Yes.
Two suits were filed. One suit is.
What is the synopsis? You have given him, not given us.
I'm sorry.
230, why did you give him at 230?
There was some delay from the government of the,
Huh?
I couldn't.
So where is our copy?
It's already served, my lord. I mean, I'm sorry, my lord. It was filed, my lord. I couldn't give the spare copy. I'm sorry, my lord. Why am I accepted? Apologies, my
13th
lord.
October. 13th.
My lord, may I request one quick, my lord? My lord, since I have seen too many matters are posted, this takes some time, my lord. Instead of
Hey, also, Mr. Sometimes Sunday has to be taken out, right?
what I'm saying, my lord, don't have it.
Today we are adjourning because we don't have this in access.
I'm ready.
But like
I'm sorry, my lord.
11 years.
I am saying that, my lord, instead of 13, take it, we can, if my lords pleases, my lord, 12th, my lord, I can take it forward. I don't want an adjournment, my lord. I'm ready for it. I want to close this issue because it was at my head for some time.
So which, this thing? What is the problem? 13th we are fixing.
I'm ready.
Huh? Learned Council so and so submits that he has filed us in.
This was the last, you will have done everything, evidence. This is the first appeal, right?
Yes, sir. First appeal, I explained.
So not a writ petition under Article 226. So we can conclude within 5 minutes.
With evidence, we are ready, sir.
Ready? Yes.
A lot of evidence is there, that's why. So just see. I have
Please, your lordship. Please, your lordship. Please, your lordship.
For the petitioner, arbitration application.
Notice. What you have in the smartphone, you have got arbitration application.
Arbitration, arbitration.
You are looking at your phone, right?
I'm sorry.
Urgent message, right?
No, I was looking at the file.
No, you looked at the mobile phone.
My apologies for that, the file.
We thought that you have arbitration application in the smartphone, so you are opening and telling us. Don't do it, Mr. That if we have permitted, it's on account of technical reasons that technology is advanced. That doesn't mean that while appearing also you will look at the smartphone.
I see your point.
225 notice. Both notice 224, 225. Personal notice, whatever you write, proof of service.
Right.
Yes. Notice. Proof. Notice. Personal notice, proof of service. Notice.
Fresh
Notice.
personal notice being completed.
Personal notice. All cases, personal notice, proof of service.
Any specific date?
You first serve and get it. It will be listed.
Right.
Yes. Yes.
I'm appearing for the respondent. Not serve the papers. We were not served with the papers.
Not served, then how are you appearing?
We filed the wakalatnama, but we didn't receive the paper.
You have not been served.
No.
With the notice.
Notice we've been. Ballots, I'll serve upon them, ballots. It's for appointment of an arbitrator, ballots.
Well, that's what we know about. Like that's why I'm sitting.
I'll have it served, ballots.
But how they have been served? Not served. Proof of service not filed. That's why he is undertaking. Counsel for the petitioner undertakes to supply copy of petition or to
Two weeks. In 2 weeks, ballots.
not something like in German. I said.
Right back.
What did he? You are not present, right? Alive to this situation. What did he say? We asked him.
I was opening a product.
That's why same thing. Mobile and this.
The calendar is stored here, so I was just opening a calendar back. Right back.
Yes.
So the counter copy ballots.
In WhatsApp.
Arbitration appeal can be allowed.
Allowed. Yes. What? What is there in this list? You keep on like trying it like a civil suit for 15 years. It must remain pending, right? That's the object. Yes. This by this in this
how much is what is the quantum?
It will be over 1 crore. Over 1 crore.
What is the nature of dispute?
That's specific performance by both the parties. He'll be saying specific performance of cancellation date. I'll be saying specific performance of the development agreement. There will be claim and counterclaim by both the parties.
Mr. Justice Chala Kodandaram. Yes. Yes.
I appeal for the respondent in this matter. I request 3 days to file counter, my lord.
What counter? You can file later on, but what is the arbitration clause is there?
Pre-arbitral steps have not been complied with. Pre-arbitral steps have not been complied with.
What notice not sent?
Conciliation. According to the arbitration clause, negotiations have to be undertaken between the parties, my lord. That has not been undertaken. We'll place it on record, my lord. The counter.
Learned counsel for respondent trace friend is granted 3 days time to.
Wait, Mr. Lordship. This is regarding the maintainability, my lordship. Maintainability in the
You are
arbitration.
for the petitioner
I am for
and you are raising the question.
No, my lordship, they raised last time that it's about maintainability. Lordship, on maintainability, my senior will come and argue by next.
No, nothing. You are the senior counsel. Yes.
Lordship, only on the maintainability.
Yes.
I have no objection.
No. You may not have. We have objection because I am a party, right, to the arbitration agreement. So therefore, I have problem in adjourning the case. You don't have any problem. You can it remain pending for 20 years for you. You don't have any problem. What maintainability?
Yes, I can commence my submissions on maintainability. I filed a memo in arbitration application number 91 of 2020.
What like memo means like it is more than an arbitration application. This is memo.
In fact, we have annexed copies of various orders, pilots, which are relevant for this case, pilots. Your lordships may see page 7.
What is it, Mr. What is page 7, page 41, page 50? Mr. Always remember you are appearing here to assist us. The court should be, you should be able to tell the point without looking at the file. If you are not, you are doing page 7, page 43 means you are preparing the case here only.
No, Malaj.
What is the big deal in a petition under 11.6?
Yes, Malaj.
What is the objection? One sentence, if you are unable to state, that means your objection is not valid.
No, Malaj, may allow me to submit.
Like this, you have filed this thing, these many pages, and nothing.
No, Malaj.
No,
your lordship.
Therefore, yes, praise for adjournment. Mr. Next date, we will decide, even if it doesn't. This is advocacy is about art of brevity, and present such without opening. You are saying page 7, page 43, page 53, 260. What is simply you should be with close the file. Learn to rely on your memory, and it will never fail you. This is what you are a young person. You are like filing 216 pages and telling the court to look at page 7. You should, without looking at the file, you should clearly tell this is my objection to and this ground 1, 2. That's the end of the matter.
In fact, my lords, on page
This is what
13 is one paragraph, my lords. It's the operative portion.
13th October, it is made. You are a senior counsel. So you tell your senior that I am now a senior counsel. So I will argue. Right? Okay.
For pledge.
230.
233 and 234 are also connected.
Unable to tell what is the objection, right? Page 7. Right.
No, my lords, page contains one paragraph, my lords. If your lordship.
Still not got it. You have not told what is the objection to the mental.
Moratorium order passed by the National
Simple, right?
Tribunal.
Simple.
Yes, my lords. However, my lords, unlike the insolvency and bankruptcy code, it's an order passed under the Companies Act, which is why.
Yes.
We have responded. File counter, my lord.
Huh?
We already filed counter, my lord.
What is it?
Request next take up the matter next week, my lord.
Huh?
Request to take up the matter next week.
No, nothing. No next week. What is it? When is the arbitration? When is the agreement executed?
Not
Agreement.
petition is. I'm for the response, my lord.
I
Already.
don't know. The respondent that doesn't, the court cannot put any question. Fine.
Actually, the condition of the petition is the payment of the security deposit, my lord.
1 minute. The court should not put any question to you because you are respondent, right? We will decide it. Don't worry. I wish all these facilities were available when I was practicing. I would have never become a judge. That you, when the question is put, you say, I am appearing for respondent. So therefore, it means that you cannot ask any question to me because I am appearing for respondent.
I apologize, my lord. Actually, it's a article and marketing agreement, my lord, dated in July 2015. Page number.
Which is the clause, arbitration clause?
Page number 66 of the petition application, my lord.
Yes, 20.3.
20.2 arbitration clause.
So how much is the quantum of this thing amount?
My lord, actually, its principal is 50 lakhs and interest they claimed around 24 lakhs. Actually, the amount was repaid to him.
That we can't decide.
Amount.
That we can't decide that he should pay further amount to you. Huh?
Already amount was paid, my lord. That is the only contention. What he is claiming to, he already received the amounts. We have filed along with the transaction details in the counter. This is the reason I think.
In 11.6 petition, we should dismiss this petition by passing a money decree against him, saying that this thing he should pay you the amount, right?
No, they are not claiming any amount from him. Page number 12 in our counter affidavit, we have filed the details.
This petition under 11.6 of the arbitration conciliation. Yes.
Lord, the respondent filed a counter. They admit the arbitration clause, my lord, clause 45. But what they say is, my lord, that clause incorporates some procedure to be followed by parties. We did not follow that procedure, so the application is premature, but that's the defense taken by them. My lord, we have issued notice in the month of March 2023, my lord, demanding the amount due from them. And also we indicated that, I mean, in case they don't pay it, my lord, I mean, they'll be going for arbitration. My lord, they did not respond. They received that notice and they did not respond to it. After 3 months have passed, my lord, I mean, we filed the present application.
Procedure prescribed page.
Well, can you say the counter filed by them, page 4 of the counter?
No, the arbitration clause.
Yes, the clause is extracted, my lord, at page 4.
Page
4 of the counter.
Item 4 of the counter. Yes.
Paragraph 5.
Yes.
Hello. Each 25(1) of the purchase order, which is extracted, each party shall designate in writing to the other party a representative who shall be authorized to resolve any disorder, dispute, controversy, or claim arising under this order in an equitable manner, and unless otherwise provided herein, to exercise the authority of the party to make decisions by order. If the designated representatives are unable to resolve any such disorder, dispute, controversy, or claim within 10 days, such dispute shall be referred by such representatives to a senior officer designated by purchaser and a senior officer designated by supplier, respectively, who shall attempt to resolve the dispute within a period of 7 days. The parties agree to use their best effort to attempt to resolve all dispute disorders, controversies, or claims arising hereunder promptly, equitably, and in good faith, and further agree to provide in a timely manner each other with reasonable non-privileged records, information, and data pertaining to any such disorder, dispute, controversy, or claim. When a party has determined it has exhausted opportunities to settle any such disorder, dispute, controversy, or claim in accordance with the clause 25(1)(a),
So what is the how much is the amount?
more than 2 crore rupees.
Yes, madam.
My lord, page 33, my lord. The informal dispute resolution, my lord.
That we have.
According to that clause, we have invoked this, my lord. In the counter, the same has been extracted, my lord. The work
We'll appoint Mr. Justice Rajshekhar Reddy. Yes. Mark the presence in this petition under section 11 within bracket 6 of
Please, my lord.
Yes.
But this is an application under section 11(6) for appointment of an arbitrator.
Ah.
But there was a leave and license agreement entered into between the parties.
Who appears correspondent?
Also filed, my lord. I have also filed a receipt.
I beg to represent, my lord, the respondents in the present case. I'm actually unwell with a very bad throat, a continuous cough. May I request the matter to be taken up week, as I'm ready to argue the matter. It's only a week that I'm seeking.
Learned counsel for respondent prays for adjournment on the ground that appears through video conferencing and submit prays for adjournment on the ground that he is unwell list on 13/10/23.
Deeply obliged, my lord.
It is your lordship. Lord, come to the petition, whether the petitioner is hearing with the supplier of service. Which agreement was
What is appearing? What? Counter has been filed.
filed. In fact, we had issued the notice and then they also had replied notice. The dispute was regarding the arbitrators. We didn't accept their arbitrator, they didn't accept our arbitrator. That's why we filed an application.
So what is the agreement?
Distributorship agreement. Dated 21.
Distributorship agreement.
Yes, my lord. He was a distributor for my goods manufactured by me, dyes and chemicals. Dated 17 December 21.
17 December 21.
And the
which clause?
32, my lord.
Page.
Page number 35.
So when did you send the notice?
Notice was sent on 7th March 23.
7th March 23. Did not reply.
He replied, my lord, on 5th April 23.
What is?
He's proposed two other names of the arbitrators, which is not acceptable to us. Therefore, we filed this application. It's matter for the respondent, your lordship.
You first finish reading the messages on your mobile, then if you have time left and if time permits, we will hear you. You are looking at this thing. This is too much. We permit mobile phones inside the courtroom. Doesn't mean that you will walk in when the case is being heard, look at your mobile standing here, and then if nothing.
I'm checking the list, your lordship.
No, nothing. No adjournment. Nothing.
Password, your lordship.
No. So what is the quantum of the amount in the
principal amount balance 57 lakhs, the interest comes to 33 lakhs, or less than a crore, just under a crore. Right.
So we'll appoint some district judge.
Yes, lordship. Password, your lordship.
Nothing.
No, your lordship.
No. You have not come here to interrupt the proceeding of the court. You appear here. Sit down, mister.
No, your lordship.
Sit down. Sit down. You don't understand English? Which is this application under section 11 within bracket 6.
I appear for the respondent, your lordship. I have no objection with the appointment of the arbitrator.
This petition, yes,
If your lordship
like former judge of this court or
this is your lordship.
all right. What is the agreement? This petition has been filed so and so. The okay. October 2023. Yes.
Congratulations.
I appear for the applicant, your lordship. Dispute arising out of a development agreement. The arbitration clause is at page.
Nobody is appearing. Madam C, served.
It is served, your lordship, and
Proof of service you have filed.
there's a respondent is already appeared, your lordship, and counted. Wakalit is already filed. Wakalit is already filed by the respondent.
My lord, I'm appearing for the respondent counsel, my lord. We have to file counter, my lord.
What counter? Not necessary. MOU dated 12/12/2022 contains an arbitration clause or not? Contains
2 weeks time, my lord.
Why?
Counter.
Like written statement every case, right? As soon as plaint is filed, thereafter we will frame issues, then you will get 15 adjournment for reducing evidence, and then he will seek time to reduce his evidence, then you will file documents that will be rejected, then 227 stay of proceeding for 5 years in civil suit. Like this, what? All this is, madam, you have to give up this sort of an approach. Absolutely. What? Everything is not to be opposed because you are appearing. Like this is all, why? This all is meant to, this alternative dispute resolution method. That too also you are converting into adversarial litigation by asking why?
Fine.
Next week.
2 weeks.
Learned counsel write her name. Respondent prays for accommodation to enable her to file counter.
I am appearing for the applicant in this matter, my lord. The purchase order has been issued.
My lords, I am for the respondent requesting time for filing counter in this matter. The dispute is of 2016 and earlier notice was issued in 2018, my lords. So plus time barred case and wherein civil suit is also pending in Rajasthan, Junjunu, and 138 complaint is pending. There is no dispute with regard to the.
So how much time? 1 week?
Not really, yeah, I need to get just 2 weeks, my lords.
So let him file counter. Yes. We'll take it up 20th October. Learned counsel for respondent press fund is granted 2 weeks time to enable him to file.
Act. Just pass on the brief chronology of the events that are
But
taking
like
place.
it's a contested matter.
Yes, I'm contesting.
Oh.
I'll give reasons.
Yes, no, you sat down from that, we inferred that otherwise you would have stood up.
Yes.
So, no, nothing, I just wanted to know, yes.
The counter, they only want the same arbitrator to continue. An arbitrator who never evinced interest in the matter. I'll just give the dates.
Yes, yes.
Trust me, kindly consider these dates. Then on 2nd November 2018, Honorable Justice so-and-so was appointed as arbitrator. Then will it trust me, straight away go to February 19 after this. From November 18 by February 19, filing of all pleadings including rejoinders were completed. Then will it by November 19, recording of evidence was completed, 5 witnesses in all. Then will it parties by consent extended the tenure of the arbitral tribunals. That is, 1 year period was over by then. Then will it the counsel for claimant commenced his oral submissions in December 2019. Then will it in March 2020, the COVID commenced and nothing could progress further. Though the learned arbitrator gave a schedule for hearing of the counsel from on all sides, but that schedule could not be adhered to because of the intervention of COVID. Then in normal courts by July 2020, the period was over. Then we were expect and the last
July 20.
July 2020, 1.5 year period was over. That was during the COVID period. But Lordship knows that the Honorable Supreme Court extended this tenure by February 28. And during the midst of the COVID period, the last communication we received from the learned arbitrator was on 8th November 2020, the last date in that list. That was the last communication received in November 2020. After 2022, after the Supreme Court judgment, at least we expected the learned arbitrator to take the initiative to recommence the proceedings and proceed further with the matter. He does not evince any interest. With the claimants tried their best, nothing could materialize and nothing has happened. So we paid, both the parties together have paid about 60 lakhs so far as arbitrator's fee out of total fixed was about 66 lakhs. Then there are about 20 hearings which have taken place. Every hearing, both the parties together paid 1 lakh rupees towards expenses, to and fro, travel expenses and other expenses. Well, all this is apart. What we are more concerned is that the arbitrator is not evincing interest in the matter after the COVID period till date. He doesn't send us any communication, not take the initiative. That's the reason we feel that by operation of this provision, all that we want is a substitute arbitrator to be appointed because it's at a stage of final hearing. Entire record is on place. Nothing should be done.
Section?
Section 29A. Can you see section 29A for a moment?
Yes.
But when I straight away go to the A1, 2 minute, they describe the 1 year period and 6 months period extension comes up.
Yes.
That may take you through the entire provision, it's a very long provision. The award in matters other than international commercial arbitration shall be made by the arbitral tribunal within a period of 12 months from the date of completion of pleadings under subsection 4 of section 23. This is amended in 2019. Earlier, it was not with reference to completion of pleadings. Then, provided that the award in the matter of international commercial arbitration, we are not concerned with this. Can we go to 2? If the award is made within a period of 6 months from the date of arbitral tribunal enters upon the reference, the arbitral tribunal shall be entitled to receive such amount as additional fee as the parties may agree. 3. The parties may by consent extend the period specified in subsection 1 for making the award for a further period not exceeding 6 months. That would take us to 1.5 years. Initial 1 year, then 6 months. Then 4 is the most crucial clause here. If the award is not made within a period specified in subsection 1 or extended period specified in subsection 3, the mandate of the arbitrator shall terminate unless the court has either prior or after the expiry of the period so specified extend the period. Provided that while extending the period under this subsection, if the court finds that the proceedings have been delayed for reasons attributable to the arbitral tribunal, then it may order reduction of fee of the arbitrator by not exceeding 5% for each month of such delay. But here in this case, though the period expired by July 2020, after the COVID period also, both the parties have not evinced interest to file an application for extension. They could have done it even after expiry of the period because the way the learned arbitrator was not evincing interest, parties have also lost their hope that anything would happen. So neither of the parties went to civil court seeking extension. That is the state of affairs today. Then my lord, KEC 5. The extension of period referred to in subsection 4 may be on the application of any of the parties and may be granted only for sufficient cause and on such terms and conditions as may be imposed by the court. But this would arise only if the parties had approached the court concerned. That has not happened. While extending the period referred to in subsection 4, it shall be open to the court to substitute one or all the arbitrators, and if one or all the arbitrators are substituted, the arbitral proceedings shall continue from the stage already reached on the basis of the evidence and material already on record, and the arbitrators appointed under this section shall be deemed to have received the said evidence and material. Similarly, if your lordships proceed now to appoint substitute arbitrator, the proceedings will commence from the stage where it was left on the previous occasion. But in this particular case, we were very keen to conclude the proceedings. Even the counsel for the claimant partly made his oral submissions, final oral submissions. So that was way back in February 2020. After that, the entire thing remains standstill. But all that we want is a new arbitrator to be appointed, substitute arbitrator, so that within a short span, the whole proceeding can be concluded. This is the limited area that submission.
Lord, I have two submissions to make for your lordship. There are two sections. Apart from 29A, section 15 also has a name. Kindly have a look at section 15. Lord, this is termination of the mandate and substitution of arbitrator. If your lordship kindly looks at clauses A and B of subsection 1 of 15, where he withdraws from office for any reason, or by a pursuant to agreement of the parties, the mandate of the arbitral tribunal is terminated. So in these circumstances, under subsection 2, as a matter of course, your lordship would be appointing a substitute arbitrator. Because in either event, either A or B, it's because of the parties' understanding or the arbitrator himself withdrawing. There is some sort of an indication that the arbitrator is lax in proceeding. Now, if your lordship kindly comes to section 29A, and also please look at the circumstances of this particular case. Admittedly, my lord, July 20, if your lordship kindly takes that list of dates. Admittedly, July 20, the mandate of the arbitral tribunal stood terminated. The language of 29A is the mandate shall stand terminated. And in this particular case, in the absence of an extension contemplated at the 29A4, the mandate has stood terminated. And thereafter, in a very leisurely manner, the applicant has moved your lordship only in the month of July 2023. The application is, I believe, signed on in somewhere in July 2023. So even if we were to reckon from 28th of February 2022, when the Supreme Court's order came to an end, and also keep in mind that there was 4 months residual period which was available out of the 18 months when the COVID commenced. This application comes after a lapse of 1 year. And the courts have now held that the entire intention of 29A is for the purposes of ensuring that these proceedings are concluded at the earliest point of time. It is so easy for parties to throw blame on an arbitrator who is not before your lordship, and say that it is the arbitrator who is at fault. Now, if I were to ask this question to myself, what was the petitioner doing for 12 or 13 months after the mandate stood terminated, and where is the letter even written by them for the learned arbitrator to take up the matter? And apart from that, if your lordship kindly looks at the pleading, they also refer to another communication from the learned arbitrator, page 16, there is a reference to that. So there is nothing which is attributable on record to the arbitrator, because it would be unfair in my respectful submission for a person who is not before the court for us to merely make the allegations orally and request your lordship to appoint another.
What is your stand on this?
My stand is twofold. Number one, under 29A4, the application should have come prior to the termination of the mandate, because once the mandate is terminated, it is by operation of law. Your Lordship may kindly have a look at the languages of subsection 4 of section 29. If the award is not made within the period specified in subsection 1 or the extended period under subsection 3, in this case, there was an extension of 6 months, 1 year plus 6 months, totally 1.5 years. The mandate of the arbitrator shall terminate unless the court has either prior to or after the expiry of the period so specified extended the period. Now, even for this, the applicant should have come with all reasonable dispatch and not after a lapse of 1 year. And therefore, his application for extension itself is belated, and this defeats the very objective of section 29A is my first submission. In the alternative, the casual request for substitution of an arbitrator, unlike section 15 where it follows as a matter of course, but 29A, it is of course your Lordship's discretion. But then there should be some reasonable cause for your Lordship to say why this learned arbitrator's mandate should not be extended. So, in sum, what I would say is, your Lordship may kindly consider dismissing the application as hopelessly barred and contrary to the letter and spirit of section 29A of the Arbitration Act. In the alternative, if your Lordship concludes that there is a quick case for continuation of the arbitration, my respectful submission, the substitution will not be ordered. And if your Lordship also kindly see the proviso to subsection 4, it even contemplates if the error is on the part of the arbitrator. It even contemplates reduction of his fees. So this is almost a punitive measure, which means that your Lordship will have to give a finding to the effect that the fault lies with the arbitrator. Please have a look at the subsection proviso under 29A4.
No, extending the period.
No, 29A4.
This extension of mandate does not arise because that has to be extended before it expires. So the question of extension does not arise.
That's my submission. That's my
right.
So,
and you perhaps you are submitting that this is not a case covered under section 15. Therefore, the question of
15 is a matter of course. 15 is a matter.
So therefore,
it's not my submission.
No, first we have got that first submission is that it is belated,
yes.
Right? And what is the second submission?
Second submission is 29A4. This application ought to have been made prior to the expiration, termination of the mandate. Your Lordship may extend it later, but the application to extend should be prior in my submission. Because otherwise, parties can come at their own legal pace. After what prevents this party from coming after 5 days? I question to myself.
So nothing prevents. After even 10 years also.
What would your Lordship do?
That's a different thing.
Yes.
Correct.
So would your Lordship countenance a party coming at leisure?
Yes.
Just one additional topic.
You are appealing for?
6 and 7.
I appeared for 1 and 2, my lord.
One additional submission is that
yes.
The application itself, the prayer is not a simple extension of the mandate of the tribunal.
No, extension can't be. Like it's substitute, yes.
Substitute. My submission is that substitution cannot be a ground without seeking extension. The substitution of an arbitrator cannot be.
No, he is not seeking extension. Like he can't.
Yes, I do.
He can't and we cannot grant. Right. Yes. Anything?
At 15, I think that situation does not arise in the present case. Those two situations contemplated in 15.
Yes.
15 has no application to the.
No, what do you say with regard to this? Your belated approach.
During the COVID period, there is correspondence on record to show all the parties by consent asked the arbitrator to extend the period because we were not in a position to proceed with. After the COVID period, after the Supreme Court judgment, we expected the learned arbitrator. The last communication we received was on 18th November 2020. That is during the thick of the COVID period.
No, that is correct. What have you done thereafter?
Yes, after 22 minutes, we expected the learned arbitrator to take the initiative. His initiative should come from the learned arbitrator. We've been waiting for the learned arbitrator to take the initiative and send us a communication for hearing. We've been waiting. Right? Under 29A millet, after July 2020, it is not only an obligation of the applicant or the claimant. Provision 4 says that either party can make an application for extension. But both the parties have chosen to remain silent on that. They did not exercise that option.
to approach the court for extension of the period of tenure. Both the parties remain silent. Both the parties are equally to be blamed for it. Both the parties did not avail that remedy. And they also have a counterclaim. That's more important. Having filed a counterclaim, they also remain silent about it. Now they come to claim us. The delay, if at all, it is applicable to both the parties equally. So therefore, in the interest of justice,
What is source for, who is the source for candidate?
that's what I'm saying. So all that I want to say is, in the interest of justice and the interest of both parties, that the arbitration proceedings which are at the fag end of the stage be continued and concluded within a short time. It can be concluded. Well, now entire record is on available with the arbitrator. First, may kindly, your lordships are agreeing with my submissions. First, may kindly make an observation that the arbitrator to be appointed would commence the proceedings from where it was stopped by the previous arbitrator.
I'll pass an order. It's not reserved, I'll pass an order.
Yes.